Oh, yeah. Sorry about that. I am muted. Yeah, I've been muted this whole time. I was actually trying to record the whole thing, but yeah. But yeah, I was saying that I wanted to actually get the direct feed from Wisconsin, the court system, but they weren't live streaming this themselves. I wonder if that is a thing that they could just sell. I don't want to say sell, but give the rights to the proceedings to court TV. I don't know. Still a public. It's still a public proceeding, so we're good. But Mandy, if you're saying things, I can't hear you. Nope.
All right, we are back on. The record appearances are as they were before.
Hi.
Mr. Brooks, I wanted to invite you back into this. Oh, never mind. I do this all the time. I need my court reporter. Kind of a small thing. Welcome, Michelle. No, that's my fault. I should have looked over there. In my defense, in my other courtroom, it's on the other side, and I got to get used to that. All right, we are back on the record. Then appearances are as they were before. Mr. Brooks, I'd like to invite you back into the courtroom if you so choose. You have been respectfully participating from the other courtroom. Of course, if you do come back in, you, of course, would be expected to abide by the rules of decorum and courtesy. Would you like to come back to this courtroom, sir?
I never stated that I wanted to be removed in the first place.
My question to you, sir, is would you like to come back over to this courtroom?
I respectfully never consented to being removed.
That's not an answer to the question.
Last time before I consider his answer to be non-responsive, would you like to come back over to this courtroom, sir?
That is not a non-responsive answer, Your Honor.
So the answers provided were not responsive to the question that I asked, and therefore he'll remain in the other courtroom.
He apparently elected not to wear the suit, Ed.
The record speaks for itself, sir.
Your Honor, I'm very tired, so.
Mr. Brooks, we're gonna keep. Mr. Brooks, we're gonna keep going. So please don't interrupt, so that we can do this as quickly as possible, so you can go back to your cell.
I was just merely trying to make the record, which you have denied me to do. As I stated at the beginning of the hearing, I would like to make an offer for my appeal. I've stated that on the record numerous of times yesterday and today as well, and I haven't been awarded that right to do so.
Mr. Brooks, I'm not going to respond to that simply because if you want to file an appeal, then you should take the necessary steps to do that. All of my decisions are on the record. You can request a transcript if you want to have a written copy of what was said in court. I can't provide legal advice on how to pursue an appeal, but I would not grant an appeal. That is not within my authority. That is a reviewing court would decide that, whether that be the Court of Appeals, the Supreme Court, or otherwise. So that's why I'm non-responsive to that, is because there's nothing for me to do as it relates to that based upon the request that you have made. So with that, Mr. Brooks,
Can you verify that by sworn
Mr. Brooks, I'm
affidavit
going to
that I
mute you,
cannot make?
okay? Mr. Brooks, you've now earned the mute button once again. Despite you saying that you're tired, you had no difficulty making objections, objecting, and once again asking for an appeal. So I need to get going on this hearing.
Thanks,
and
Mark,
that's
for the
what we're
7
going
months.
To do, I would like the state to confirm on the record whether you've had an opportunity to have the motion served on Mr. Brooks.
Yes, Detective Reglan personally served it on him about 10 or 12 minutes ago, Your Honor.
Overturn Ferretta.
Also at the same time served him with a copy of the state's exhibit list, which I believe we will be addressing at later this hearing.
Right. As to the motion, I would like to give him an opportunity to review that. It is a motion for reconsideration. And so I'm not going to address that today. I'll have to address that tomorrow morning.
Understood.
Thank you.
My volume is low. I don't know if it's low.
Why
think
don't
I'm
we
fine.
start with one of the latter things that you indicated, and that's the criminal records for state's witnesses. How many witnesses would this issue relate to?
One.
All right. And would you have a copy of that record, or I don't know if how do you provide that to the defendant? How would you like to provide that to him, at least the information?
Well, I'm prepared to make an oral statement today, and then I have a CCAP entry that I would choose to provide to Mr. Brooks to verify what I'm saying.
Okay, go ahead.
Your Honor, this relates to
I'm really hungry
one
right
of the
now.
state's potential witnesses who's identified as the father of victims KKK and victim LLL, who is expected to testify. He has one prior misdemeanor conviction from 2005 for a crime of entry into a locked building. I would note that it's the request of the state that although he does have this one prior on his record, the court make a finding that it's not relevant or probative, in that he was 21 years of age at the time it occurred. It occurred 17 years ago, and there's been no further events or criminal wrongdoing in the meantime. I don't think it is probative of his truthfulness. It was not a crime of truthfulness, and we would ask that although that record does exist, that he cannot be asked about it when he testifies. He is the only citizen witness that has any appropriate criminal record to discuss.
How old, again, you said it was 17 years ago, but how old was this individual at the time?
21 years of age.
You have the statute handy.
906. 90609, Your Honor.
So I'm going to take this request under advisement. I'm going to advise Mr. Brooks that the relevant statute is 906.09, impeachment by evidence of conviction of crime or adjudication of delinquency. I have provided him with that selected statutes book, so he can review this if he so chooses, and then at the appropriate time, I can readdress this.
I'll remind you before this person testifies, Your Honor, if not before, but.
Right, I think that would be the best way to do this. Just maybe give us, if you can, a day or two notice so that he can, meaning Mr. Brooks, can look at the statute again if he so chooses. So what I'm telling you, Mr. Brooks, is that I'm not going to address this request today. The state's put this information on the record. I'll require them to provide the CCAP information that they have regarding this individual. That individual would be on the witness list. Is this person indicated in any way on the witness list as the father of so-and-so, or would it be?
No, but when he gets the CCAP entry, he'll see the name.
That's true.
Yes.
All right, thank you. So that's how you'll get that information, and then I'll address whether that impeachment evidence is relevant and probative at a later point in time, but at least you're put on notice of the request. And again, I'm not going to address the motion for reconsideration because you were just served with a copy of that. I will take that up tomorrow morning.
If the defendant should testify, we would want to discuss his prior convictions as well. We don't have to do that right now, but I at least wanted to discuss about the state's witnesses, Your Honor.
Sure. If you wanted to provide a little bit of information, again, he's been given the statute. He could review that. Do you have a total number of convictions for Mr. Brooks, and the number that you would ask be the number he answered the question to? Should he testify, have you been convicted of a crime, and if so, how many?
Yes, Your Honor, we believe the answer would be 12, with the first 3 coming from the state of Nevada, and then the remaining convictions all in the state of Wisconsin, mostly from Milwaukee County, but also 1 conviction from Wood County and 1 conviction from Manitowoc County. And we would certainly provide Mr. Brooks with either a criminal history or CCAP printouts, whichever he would like, to support these convictions, except for the Nevada. That would be on his criminal history. We can provide him a CIBR.
All right, so the state's putting you on notice that if you elect to testify in this case, they will be seeking a ruling on whether you may be asked, have you been convicted of a crime? And then the follow-up, if that answer is yes, is how many times? And that number is really up to judicial determination under the statute and relevant case law. Again, not going to take it up here today, but you're put on notice, and the state will provide some information to you to substantiate the convictions. I'm going to unmute. Do you have any question about the use of criminal records for witnesses and impeachment, at least the mechanism for which to address those as I've outlined here today?
I think once I'm able to review things, I will have a better understanding. At this point, I don't
That's
understand.
okay.
So,
Understood.
I do want to just say one thing, and not to that. I just wanted to state one thing on the record, that I did inform the bailiffs that I did not wish to accept the paperwork that was brought off by the detective. I don't know his name, so I don't want to be disrespectful. And
The information I have is Detective Ragland did personally serve you with that. He'll file the appropriate service if need be. Whether you take that paperwork with you or not back to your cell is your decision, sir.
well, I just wanted to put that on record that I'm not accepting the paperwork.
Your objection to the paperwork is noted. All right, that might be a good point to talk about objections during trial. That's
Oh
a good
boy,
segue.
here we go.
We talked a little bit about that during the testimony today of the jail administrator. Sir, once again, I direct you to the rules of evidence. I actually have a large binder that I utilize as judge on the rules of evidence. There are many rules as it relates to the admissibility of evidence, foundation, authenticity, etc., and other things. Typically during a trial, because I'd like to minimize the information that's before a jury, is I ask parties to, if they have an objection, objections generally speaking go to testimony or evidence. So for example, if a question is asked that you think calls for inadmissible evidence, you let the attorney asking the question fully ask it. You say objection. If it's a relevance objection, I'd like you to say relevance. If it's a hearsay objection, say hearsay. I don't mind a sentence or two. Try to avoid is a full legal discussion in front of the jury. If I feel it's appropriate once the objection is made, I'll either sustain it, overrule it, or I might say to the other party, so if you're making the objection, I would say to the state, any response? They might say something like, let's say you make a hearsay objection. Your Honor, it's not hearsay, it's
I just wanted to make sure that worked.
for the truth of the matter asserted.
Damn it.
That triggers to me, I understand what I need to decide at that moment, and I might say sustained, or I might say overruled. The witness may answer. The jury's instructed that the information or the testimony being provided is not being offered for the truth of the matter asserted, something like that. However, if it's a more complicated issue, sometimes the state will tell me and ask me, Judge, may we have a sidebar? We don't really have sidebars in a situation like this where you're in custody, but using that phrase is still acceptable because then it prompts me to have the jury excused, so then I can have a more full discussion with the parties, hear their legal arguments and reasoning. Sometimes it requires an offer of proof. And so what I'm advising you, sir, is because the state bears the burden of proof, they're going to go first. They're going to present witnesses. If during testimony you believe certain testimony is not admissible under the rules of evidence, you can certainly object. I'll rule on that objection. I ask that you wait till I rule on it. But once I've made my ruling, it's either going to be the witness will be allowed to testify or the witness will not. So whether you're the one making the objection or the state's making the objection for something your witness might say, I expect that you will honor the ruling and then either move on to the next question as the case may be, or, for example, if I've overruled an objection of yours, to allow the witness to answer. And the record will reflect that an objection was made, and that will be there for appellate purposes later on. If we get to a point in time in the proceedings where you have been removed and you are appearing from the other room and you are not able to follow this procedure, I will warn you now that I may mute and probably will mute in those circumstances. You have been given the objection sign. You can raise it. I will unmute and say the basis for the objection, sir. You'll state it. I'll mute you again. I'll rule on it, and then we'll go on. If at any time, though, that even that secondary process is very disruptive, then I will require you to write down all of your objections. And then let me rephrase that. I'll require you to write them down. If that means I have to wait for the sheet of paper to come over, I will. But at some point, sir, I'm going to keep this trial and the testimony going. I would direct your attention to 906.11. So 906.11, which concerns the order and mode of interrogation. The judge maintains the ultimate control over that. And if you intend, or if at any point in time you just simply object to every question, that is not going to be acceptable. Because also under 906.11, you can't harass a witness that way. So I want to make that clear. Attorney Opper, is that a procedure? Does that answer your questions about the procedures for objecting?
Yes, that answers our question as to objections. I did have another question about, in the event Mr. Brooks has forfeited his right to be present in the courtroom and has been removed, how will cross-examination proceed?
Well, I've reviewed the case law, and
That's a good question.
one of the possibilities is that he forfeit his right to cross-examine. If he's not in this courtroom, it's can be challenging to facilitate cross-exam. And if he's able to abide by the rules of decorum and civility, and whether it be even objections, right, or cross-exam, I mean, that can be shut down, for lack of a better way of saying it.
I understand that, and I know this court has been more than patient. We would just ask the court for its continued patience. We want Mr. Brooks to be able to confront and cross-examine his accusers. He has demonstrated on the 2 occasions so far that we've had testimony, he's quite efficient at asking questions, and so if he is calm and cooperating and not rude and disrespectful, we believe he should be given the opportunity after every witness to cross-examine. Even if he's in the other courtroom, we should at least make that inquiry, unless it becomes absolutely not an option because of his conduct.
I would agree.
Okay, thank you.
So, just so I understand, because I don't, how can I,
Just so I understand, though I don't.
to actively
Fucking idiot.
and effectively participate in a trial if I have to constantly be put in a separate location? How will I be able to see everything that is going on in the courtroom? How will I be able to effectively put on a proper defense?
Mr. Brooks, I direct your attention to Illinois versus Allen. That's the case that I've been relying upon regarding your removal. That's found at 90 Supreme Court 1057 from 1970.
Just so I understand, the Supreme Court, the federal court,
That is the Supreme Court of the United States of America.
is that federal?
Oh my
That
God.
is the Supreme
Yes.
Court of the United States of America, sir.
I'm just really seeking to understand, Your Honor.
Sir, that is
Don't
the Supreme.
understand, so-
Sir, I've answered the question.
You have, but I still don't understand. That's why I'm asking the question. I'm not disputing it.
Sir, I'm not going to explain the law to you. I cannot do that.
I'm not asking you to. I'm asking, is that a federal court?
All right, I'm going to move on to the next topic. Related to objections would also be to the admission of evidence. Of course, my standard practice when a party offers an exhibit is to say any objection. And so if there is an objection, of course, there needs to be a legal basis. And then once I rule on that objection, then I expect that decision to be respected and honored, and the testimony and presentation of evidence continue forward.
So, Your Honor, I still don't understand. How am I expected to do everything in a legal basis, in a legal manner and everything, when I keep informing you, Your Honor, on record, in open court, that I did not understand, that I still have yet to understand the true nature and cause of the charges against me, which I don't understand.
He's going right back to it.
There's so many things that I do not understand that I keep explaining to you, Your Honor, that
Mr. Brooks, I'm going to refer you back to document number 244, which is the waiver of right to attorney form that you willingly, knowingly, intelligently, from my perspective, understandingly filled out. Let me make my ruling, sir. Do not interrupt, or you will be muted. All right?
Just mute me then, Your Honor.
So from my perspective, sir, we clearly went through not only this form, but really the topics that are referenced in this form, the advantages of having an attorney represent you, the disadvantages of representing yourself. I discussed with you and advised you regarding all of the charges that you face, the penalties that you face, the exposure that you face. I advised you regarding what an attorney would do. I further advised you about the disadvantages of representing yourself. I asked you such questions about whether anyone, forced you or coerced you to waive your right to an attorney. I asked you if anyone had made any promises to you to waive your right to an attorney. I made a finding, sir, that you freely, voluntarily, intelligently made a deliberate decision to waive your right to counsel and to represent yourself. I refer you to that document, sir, because once again, I cannot give you legal advice. I cannot explain court procedures or the law. And you represent yourself at your own peril. I honored your request to represent yourself, and it's a bit disingenuous to now say you don't understand what you did. So we're going to keep going. I need to go through some other topics. You are not muted, but there's nothing for us to discuss at the moment.
I'm not trying to discuss anything. I was just letting you make the record, which I haven't been afforded the opportunity to make the record when I offered for my appeal. Again, I do not understand, and Your Honor, I think it's very unfair for you to say that you're finding that I understand. How can you tell me what I understand and what I don't understand? I've clearly made that very, very clear that I don't understand. And the same document that you referred to that I filled out specifically crossed out the word understand. Why did I do it like that? Because I do not
Mr. Brooks,
understand.
I'm going to mute you because we're off topic. We've gone over this time and time again. I understand the objection that you're raising. You once again are claiming that you do not understand. I make findings in this courtroom based upon the available information, the law.
He's trying to play. Well, I mean, it's obvious to everybody here. He's trying to play word games.
All in the record for which you can appeal at a later point in time. But we are going to continue whether you claim to not understand. All right, so I need to add one instruction to the preliminary jury instructions. Have we provided Mr. Brooks with his another copy
Thank
yet?
you, Pat, for the 7 months.
Another copy, just the one from last night.
So the one from last night, my understanding is he left in his cell.
Of preliminary jury instructions? Not that I'm aware of, no.
So you can print off what we have thus far for him, Madam Clerk. And I'm going to just make a modification and print off a separate instruction that I have crafted regarding decorum and courtesy in the courtroom.
I know guys saying he's not legally competent. No, this guy is competent. I think the judge knows it, and I know it. The judge and I both know that he's playing games. He's not like doing this because he doesn't know what the fuck he's doing. He knows exactly what he's doing.
So he was provided with the packet of preliminary jury instructions. So let me I just need to add a line in here. I'll print this here for the state, and I'll print it in the other courtroom. There's a printer over there as soon as I do that.
You mean just this one?
Just this one, yeah.
Okay.
I mean, it'll be a very interesting question whether or not the crossing out of the understand will be the focal point for an appeal. I don't think so. It would all depend on the record, which I think the judge is doing an excellent job of making sure that everything that needs to be put on the record is on the record in terms of what he says, how he's saying it, and what he's doing with regards to the entire proceedings. Yeah, the whole sovereign citizen shtick is that they think understand means stand under, or I stand under your authority, which sovereign citizens never want to do because it's a whole thing of they don't want to assent to their jurisdiction. If he didn't truly understand, Grixie, you made the point. If he truly didn't understand the document, the waiver form, he wouldn't actively cross out the word understand and replace it with inform and sign it.
All right, a copy of this should be on the printer in the other courtroom. And then I'm providing a copy to give to the state.
Did you email that to me?
I sure can.
Possibly, Taze, yeah.
All right, I'm gonna unmute Mr. Brooks for now. I was not looking at the monitor because I was sending the email to my clerk with that document, but I just need to get confirmation that at least it was put in front of him on the table.
An idiot.
Whether he accepts it or not, I understand, but Mr. Brooks, was that piece of paper placed in front of you?
I don't accept or consent to any paperwork.
Judge, I did see on the monitor the bailiff set some paperwork on the table in front of Mr. Brooks, and he took it off the table and set it on the floor next to him, it appeared.
He's putting in the record.
All right,
Again, that's
for
good.
making that.
Accept or consent to that.
That's good.
I don't
That
accept any more paperwork.
the state acknowledging,
Brooks, you made clear
putting
you
that on the
want to
record is
accept paperwork,
important.
But we have an obligation, whether you make that statement or not, to provide you with copies of everything the court is addressing with the parties. So what you do with them is up to you. So your objection is noted.
You may be aware that certain things are not going to be awarded, especially when it comes to fairness.
Mr. Brooks, I need to move on to the jury instructions. Are you willing to participate in this process right now?
No, I am not. And
No,
I
he's
don't
not.
give consent without me being present in the courtroom, like I said before I was brought over here.
Would you like to come back over?
So why would you ask me now? Why would you ask me now?
Mr. Brooks, you were put over in that courtroom because of your disruptive behavior.
I
If you
wasn't
can
being
agree to
disruptive.
abide by the rules of decorum and courtesy,
I'm not gonna agree
then
to
I will
anything.
bring you back over here at any point in time.
I'm
Did
not
you
gonna
hear me
agree to
advise you
anything.
of that, sir?
No, I did not.
You're advised, sir, that if you want to come back to this courtroom, you may make a request at any point in time. If you come back, the court expects you to follow the rules of decorum and courtesy that you've previously been advised about.
So is this how it's gonna be the whole trial? Every time I seek to understand
Mr. Brooks, I'm
something,
offering you the
ask
opportunity to come back to this courtroom
I
to
just-
participate
I just-
here.
I don't wanna go over there and then essentially have to come back right over here, because when I ask something that I don't understand, it's being looked at as me intentionally trying to disrupt the court.
Mr. Brooks, I'm asking you a question. Please answer.
I asked you a question. I
Would
asked you
you-
a question as well, Your Honor.
Oh my God.
Would you like to come back to the main courtroom right now? Yes or no?
I asked you a question too, Your Honor. I've asked.
All right,
is
I'm
this
going
gonna
to
be
mute
how it's
him.
gonna go?
I'm going to make a finding that his decision to not answer the court with a yes or no is non-responsive. I repeatedly asked him if he would like to come back to this courtroom. He did not answer yes. Instead, he wants to debate with me about his understanding or lack thereof, and rather than discuss the topics at hand. I find that behavior to be rude, to be disrespectful. I find it to interfere with the orderly administration of justice. I want to continue with the preliminary jury instructions. Of course, it is always my preference to have Mr. Brooks in this courtroom, but as he has been advised repeatedly, in order
Justin,
for him to maintain
trying him
his
in absentia
appearance
is
in
an
this
absolute
courtroom,
last resort.
he needs to abide by even the most simplest of rules, and that is to not interrupt. I will not tolerate disruptive conduct that, from my perspective, is simply an attempt to avoid being tried on the charges brought before this court. All right, so I have a packet of jury instructions, and if I didn't state it, obviously the record should reflect I have muted Mr. Brooks. And he'll remain that way until he sends me a note indicating he'd like to be unmuted and that he will comply with the rules of civility and decorum. All right, so I've provided the parties with a packet of instructions. There are 68 pages.
Damn.
Attorney Opper, will you or Attorney Basie be addressing the preliminary jury instructions?
I will, Your Honor.
All right, do you acknowledge receipt of those?
Yes.
All right, I will put on the record that the 68 pages were also provided.
Oh my God,
to
he has
Mr.
a
Brooks,
sign.
earlier today, I believe, at the start of the hearing. And then he was also provided with the single-page proposed instruction regarding decorum and civility that the court has drafted. Has the state seen that as well?
We have.
The only
I
thing
get it, Woodward.
I'm noting at the moment, on page 1, Madam Clerk, is a footnote that needs to be taken out. Then, does the state have any corrections, edits, or suggestions at this time?
Your Honor, we do not. We did have a typo with regard to the name of one of the victims. I did email your clerk. I believe it has been corrected, but if not, it would be regarding, it was on page 28 of 69, specifically count 65, and the first name of the victim was, there was an S that needed to be removed.
Did you say count 65?
Correct.
There's an S in the first name that needs to be removed?
Correct.
All right, I must have the old copy, but I'll make a note of that.
I had to do a save as.
Oh,
Okay.
hell yeah.
Anything else?
No, Your Honor.
My thought on the instruction that I provided to the parties, there is instruction 70, which
Wings, or no, the tacos are on its way, baby.
Copy, Teresa, so I'm
Tacos
the
are
same
on
page,
its way.
literally
Or I could share
and figuratively with
Or
everyone.
would you rather I shared it, or?
Sure. Mr. Brooks is raising his objection sign. If he has an objection, he needs to write that out and provide that to the bailiff so that I can then take it up. So, no, it would be a far ahead.
Oh God, what have I done? Oh no.
All right, so as the parties can see on the monitor, 70 is the instruction that is entitled in the drafts that are provided by the standard or pattern jury instructions. Preliminary instruction, defendant, proceeding, pro se. Now, I would note, none of these headings are read during the advisement to the jurors. It's really so we can keep an orderly list of the instructions. So my practice is to simply read, starting with the substantive. So that is the pattern instruction. It's been modified to make sure it says himself versus herself and the name of, actually it just says defendant, there is no name. And my suggestion and what I intend to do is to, right after where it says in any manner, is to start a new paragraph. So just underneath that, whether it has a heading or not, I don't think is relevant at this point in time, but to read the following. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that Mr. Brooks's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. All parties in the courtroom, including the attorneys, the litigants, witnesses, the judge, the jurors, and those in attendance, are expected to conduct themselves appropriately and avoid creating disorder or disruption, as well as conduct themselves in a manner that demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. I would not read the SCR unless there's a request to do so. That is there just for reference. That's where I pulled that from. There's a second part to the proposal that if at the time the court reads the preliminary jury instructions, Mr. Brooks is not in the courtroom, then to add the second where it says to be read only, that says at the moment Mr. Brooks is appearing from another courtroom, this must not influence your verdict in any manner. I understand Mr. Brooks is objecting. I'll give him an opportunity to make any statements regarding that on the record. I'll ask the state first whether there's any objection to inserting this in that location.
No objection to it inserting that. I would just note that in all of the jury instructions, I don't think we've ever mentioned Mr. Brooks by name. I think it's always been the defendant. I don't know if the court wants to be consistent. That was my only comment.
I think it would be good to be consistent. If I read this at all at other points in time, I will use his name that I have listed on this proposed. All right, Mr. Brooks, I'm going to unmute you so that you can put the basis for your objection on the record.
Yeah, first of all, I'd like to state for the record that I'm pro per, not pro se.
Oh my God.
And what you just said about keeping it consistent, then it's been in this form ever since it was brought up. So why start to change the language and logistics of it now at this point to constitute me being in a separate location? If it's going to be consistent, then it should be consistently as it was constructed. Nothing should be changed.
Sir, do you have, want to make any statement related to the jury instructions that I've provided to you, whether you object, consent, agree, or otherwise?
No, I don't consent.
Of course he doesn't.
Nah,
All right, your lack of, sorry, go
I
ahead.
just stated the reasons why.
Is that to
You
the
just
whole,
said so yourself. You just said so yourself. They need to be consistent. So why does anything need to be changed at this point?
as to the entire packet that was provided to you, noting I've made this change, I will,
didn't
hold
accept
on,
anything
hold
that
on,
was.
hold on. I will advise you that as to the added paragraph, I will make it consistent with the verbiage and the pattern instructions and refer to him as the defendant. However, if I have to read this instruction at other points in time, I will be reading it with the verbiage of Mr. Brooks. I do that, frankly, out of respect for him. But the pattern jury instructions are constructed in such a way that I'm going to follow that pattern when reading instructions. with the exception that I've just noted, and that is if I am in the position where I feel it important to advise the jury, whether it's just simply that he's in another location or another courtroom, this must not influence your verdict in any way, or if I feel it important to read the entire thing. I'll take out the reference to SCR 62.02 sub 1 sub F and H. That was really just so the parties understood where I obtained that language from.
What's being changed, or is it, I don't understand,
I changed where it said Mr. Brooks to the defendant. And that, I think, was in
no,
two.
it's still saying it, it still says.
Is it in the court of
That
sentence
name.
ensuring that part?
Yes, so right there. We're in the process of changing it, sir. My clerk is typing as we go along.
Thank you, and I also want to make.
Small d.
State this on the record, you just referenced, wanting to protect my rights, correct?
You have
As
the language
always.
in front of you, sir.
Well, you just said on record that you will want to preserve my rights.
Mr. Brooks, you have the language of the jury instruction immediately on the screen in front of you. Do you have a question or a position on whether that's included?
I was getting to that. You did not let me finish. So it's not a question. Like I said, I was stating for the record. Part of protecting my rights would be the ability for me to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
Do you have a jury instruction that you would like me to read that would state that? Have you drafted anything, sir?
I wouldn't need to draft anything if it's already in the Constitution.
Oh my God.
I should be able to be afforded for those rights to be protected under the First and Sixth Amendment.
I'm sorry, I mistook what you were saying. I thought you wanted me to add a jury instruction, a written jury instruction, so that I would read something to the jurors. Am I mistaken on that?
I'm not gonna consent to any.
He's trying so hard not to fall into some sort of make-believe trap.
Because I'm referring to you saying that you would like to preserve my rights. And part of my rights being preserved is to be able to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
So, as I understand what you're saying, sir, I think what you're asking this court is to add an instruction because the jurors get informed. Hold on, let me finish. The jurors are informed of the law through jury instructions. These are the pattern jury instructions with the exception of what I've just added to number 70, which I feel is appropriate in this case. If there's something additional, then tell me what it is, and do you have a draft to provide to the court for consideration?
Well, how about this, since it's clear that you're not grasping quite what I mean by what I'm saying. How about I draft something up and get it to you as soon as possible? Would that
Fucking
be
idiot.
sufficient for your honor?
If you draft something and submit it, and we have it by tomorrow morning, I can address that on the record, and whether it will be included or not. So yes, that's acceptable.
For the record, also may I state, and it's going back to the language that says pro se. Can that be changed to pro per?
That's not read to the jury. It's just part of the labeling. But it is my pattern, but it is the pattern jury instruction. That is a phrase that has meaning in Wisconsin law. It is accurate, and so your request to change it to pro per is denied.
Okay, how is it accurate?
That's my ruling, sir.
I don't understand, so I'm just seeking.
Mr. Brooks, that's my ruling. I need to finalize these, Mr. Brooks, I need to finalize these instructions, so my question to you is, oops, you can take that up.
Again, I did have one suggestion.
Okay.
On the second.
Hold on, just,
Sorry.
Mr. Brooks, what I want to tell you is, I'm going to finalize these. The state has a suggestion for verbiage within an instruction that's already in there that I'm going to address. I'm then going to ask you whether you have any other edits or requests as it relates to them, and then ultimately ask you whether you approve of these or not. I just want you to be advised of that. So go ahead, Attorney Basie.
Thank you. On the additional language that the court is adding to jury instruction 70, I would just state on that second sentence, my job includes making sure the defendant's rights are protected. So I think that should be the.
Right there.
Yep. Or I could just read, sure, the defendant's rights, whatever.
Since nobody's saying anything, part of my rights being protected would be to be able to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys. That's another right that's not being protected.
If you're requesting that language be included, the request is denied.
And is that a judicial determination that I won't have?
I do not believe that accurately states.
Right preserved?
I do not believe that statement accurately reflects the law. All right, so we'll make Mr. Brooks, I'm moving on.
Can you show me by?
Mr. Brooks, I'm gonna mute you. I'm not required to show you verification of law. Again, I direct you to the waiver of right to attorney form, a copy of which has previously been provided to you about what this court can and cannot do. That's a very good summary. If you have any other questions about what the court can and cannot do, I also direct your attention to the Supreme Court rules. My understanding is you have access to legal materials, and there are a number of rules that apply. The Code of Judicial Conduct is SCR Chapter 60. All right, we've made that change. With that change, does the state approve of the jury instructions?
Yes.
All right, Mr. Brooks, I'm going to ask you that question. Actually, two, do you have any, and you're raising the objection. Hold on, you're raising the objection sign. It's noted for the record.
Here we go.
That's the only way I can.
No, I know, and I'm making a record of it, sir. But we're at the point in time, do you have any requests for edits? Let me finish the question, sir.
It's going to be a...
You're interrupting. All right, I'm gonna have to mute him again so that I can get my question out. Mr. Brooks, my question to you, do you have any other requests as it relates to edits, other instructions, or corrections of the 69-page instructions that you were provided with? And the added
It's going to be
instruction that
a
you were able to see on the
mukbang
screen.
briefly, so ignore
Go ahead, you
my
are
eating
unmuted.
habit.
I wasn't looking at anything on the screen, and I already made clear on the record, and you just confirmed on the record that I will be able to draft something up and get it to you. So why can't I address anything in that draft?
Sir, I am addressing what we have now. So I will ask you now at this point, since you've not answered my question, I understand that you're going to draft something. Other than that, do you have any other edits, corrections, or requests for inclusion at this time related to these jury instructions?
Yeah, you still haven't answered if I'll be able to inform the jury of the truth, their rights, and their duties.
Sir, I have provided an answer to that. All right, I'm going to object. I'm going to not object. I'm going to mute him again. I have told you, you will have the opportunity to draft a proposed jury instruction for inclusion with this packet. At this point, he hasn't answered my question directly, and by his responses, I will make a finding that he's not responding. It's a non-response type of answer. Because I've advised him as to what I intend to do, I am going to approve the jury instruction packet that has been provided to the parties and modified on the record.
Your Honor, I do have one other change I just noticed,
Go ahead.
and it's with regards to the bail jumping jury instruction. I know we had talked about this verbiage before, about the theory of that charge. The theory of that charge is that the defendant committed a crime. It was our belief that they did not have to be unanimous on the crime that was committed. As I look at the jury instruction, and it's talking about the third element, it says the state must prove by evidence, and I'm on page, 66 of 69. Your paging may be a little different because I think you have the added verbiage. Elements of the crime that the state must prove.
The number one is to each count. That one?
No, it'd be, if you go down to the third one and the paragraphs that follow,
Right.
number 3. So the last paragraph before deciding about intent and knowledge, it indicates the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, and battery. The crimes, and then it lists those same crimes have been defined for you and should apply the same definitions here. I would just indicate, I believe it should read hit and run resulting in death or battery. I believe that they do not need to be unanimous on the crime that they select, but they do have to be unanimous that he committed a crime.
Mm-hmm.
Any case law or other support for that position?
No, Your Honor, I know that the court had addressed the hit and run, that they don't have to agree on which ones they violated, and that would be the analogy I would make. I know we had talked about that previously. I mean, what we could have done is to Mr. Brooks's benefit that we did it this way, because it's only 2 counts of bail jumping versus doing 1 count of bail jumping for each crime that he is alleged to have committed. We put them together, I guess, to the benefits, and he may not see it that way, but to his benefit.
Mr. Brooks, the state is specifically asking that I change the word and to or under the third element of bail jumping based upon their theory of this case and the bail jumpings and their belief that the jurors do not need to be unanimous as it relates to which crime was committed. And they're asking that I insert the word or as indicated. Do you have any position as to that?
Yes, I do. And I'm gonna base my position off of what you just said, that there is no case law to support why it should be changed. I believe that it should be whatever it is right now, that the word or whatever should not be admitted, it should be how it is right now, as apparently it was intended to be that way all the way up until this point, so why change it now? Let's just leave it alone and leave it where it is.
Well, actually, sir, the pattern jury instruction was modified because of the charges in this case based upon the state's proposed jury instructions that were previously filed. The pattern jury instruction basically deals with a single criminal law violation. That's not the theory of the case for the state here in this case as it relates to the bail jumping counts. So I just want to be made clear that it's not a change that they're asking to the pattern instruction in terms of what would have been there previously, because it already was modified based upon their theory in this case. To say it another way, the pattern jury instruction didn't contemplate, and they're just that, they're pattern jury instructions. Oftentimes the courts have to modify based upon the particular nature of a case. My question to the state, and then will be to Mr. Brooks, is if I adopt the request from the state, do I need to put in a similar statement like what is in the hit and run about you don't need to be unanimous as to which crime he committed, but you need to be unanimous that he committed a crime?
I think that would be helpful to them. I think the paragraph before the one I just recited says the defendant is charged with violating a condition of bond that required that he not commit any crime. So I think that verbiage would be consistent with that first sentence.
Any position on that, Mr. Brooks? Or the, sorry, go ahead, any position on that?
Yeah, I don't agree with why should it matter about a unanimous or not being unanimous if
My God.
If that was always the case from the beginning, then it should have been changed at the beginning.
He has no idea what the issue
At
is.
this point where everything is so close to being decided, I don't understand why it needs to be changed in any way, why it needs to be altered in any way. I think if it was going to be that they have to be unanimous, then let it be unanimous. Let it be unanimous for everything.
Right, I agree with the state's position. I think that's the most appropriate under the law, given the violation of bail jumping. It can be a variety of different ways, but in this particular case, the state's relying upon that statutory subsection for violating any crime. So in element number 3, it needs to say the state must prove by evidence the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree reckless endangering safety, use of a dangerous weapon, hit and run resulting in death or battery. And so that I actually took out, where it says crimes, I changed that, I took out the S as well. I think that you would need to do that, or I would need to do that in order to be consistent with the or. So I'll make that change, and then
Yes.
Can I make the suggestion that at least, at the minimum, it would say alleged crime, as I have not been convicted of anything?
I understand what you're saying, but these are the jury instructions that tell the jury what the elements of the offense are. It's very clear when you look at the jury instructions in their totality that these are the elements, that the state bears the burden of proof. There's other parts of these that talk about an information, that these are, that can't be used against you. I believe your concern is adequately addressed when you read the jury instructions as a whole.
May I ask Your Honor if there's anything that I can look up myself that would help me better understand this.
Oh my god. Bitch! This is what happens when you do
Can't answer that for you,
self-representation.
sir. I can't explain the law to you. I know at times I've provided you with resources. I mean, what I have available, but I have no idea if you would have access to because it's through a publication. I believe through the state bar are the jury instructions. I'm not even sure if what I have, to be honest, I know I get them through the Director of State Courts office. I have them available electronically, and the Jury Instruction Committee, which is, let me take that back. It's through the law school because of the Jury Instruction Committee, and it's a publication. I'll be honest, I don't even know how the public gets access to them because of how I get my access. It's just something that the Director of State Courts office provides to me through my judicial dashboard. And so, but what I wanted to say is those jury instructions come with comments. There's also special materials. I don't know how you access those outside of the way I do. It's been over 10 and a half years since I've practiced law, and the whole electronic access to these types of things have changed. So I'm just not able to answer that, sir.
And Your Honor, I think I can provide some clarification. I believe that they are accessible through Law, and the defendant would have access to that on his tablet.
Oh, thank you.
No, I'm sorry, on the computer in the conference room.
All right. You'll want to probably check the computer out to see if that's true, but the state has information to suggest that you would have access through Law to the jury instructions. The packet that I'm giving you has all of the numbers on them, so that should help you in your research of them.
So I think where my the most glaring part to me of my misunderstanding is the unanimous, ununanimous thing. I think that's what I'm really attempting to wrap my head around at this point.
Man.
Right. I'm trying to find the language in the hit and run about the duty that I would.
You know
point
what would help you,
to.
man? If you had an attorney.
That's what.
Your Honor.
61 of 69, under number 3.
Oh, right, I found it. So I'm just going to point you to, under the jury instruction for duty upon striking a person, which is instruction 2670, under element 3, there's a portion of that that says, the state is required to satisfy you beyond a reasonable doubt that the defendant violated at least one of the two duties, but you are not required to agree as to which duty was violated. The proposed language that I would have is that the state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree as to which crime was committed. And I would put we're talking about the bail jumping jury instruction. It's also element 3. Right after where we says all of these crimes have been defined for you, and you should apply the definitions here. I think it would make sense at that point to say the language I just proffered, which is the state is required to satisfy you beyond a reasonable. Actually, let me take that back. I'm looking further up where we're closer to the number 3. So it's my page 65. I don't know if it's 65 or 66 or 64 in yours, but
Those are some good ass tacos.
where it starts with the defendant is charged with violating a condition of bond that required that he not commit any crime. And then it has a paragraph, and then there's another paragraph that starts, the state must prove by evidence would satisfy you beyond a reasonable doubt. It's before I say the crimes of have been defined, that's where I think it should be inserted. And so, Madam Clerk, where we made the change where it says or battery,
Yes.
then we'll include the following language
Thank you, Carl, for the $5.
after, it'll be its own sentence.
Okay.
The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree as to which crime was committed. Mr. Brooks, when we get done here today, I think it's fair, since we've been here quite long, I don't intend to have a very lengthy discussion tomorrow, but I'll print all of these off for you, so you can review them tonight. That'll also give you an opportunity to look at some of these topics, as well as if you want to draft your own instruction on some law. And then first thing tomorrow morning, we'll have a very brief discussion. It's only on these added the language, not the whole packet. The other parts of the packet have been approved by this court. But that'll give you an opportunity to further look at it.
Can I just make sure I got it?
And Madam Clerk's going to read it back to me to make sure it says what I want it to say. So go ahead.
So after hit and run resulting in death or battery, the state is required to satisfy beyond a reasonable doubt that the defendant committed a crime.
Hold on, you're going to need to slow down a little bit.
Sorry.
And I think there's already a word missing. Let me just get to that.
Yes, he did this all while out on bail, Hitchbot. Yes. So of course they're gonna attack on bail jumping.
Okay, go ahead and start over.
Wait, I was just informed they couldn't hear me in the other room, so I'll speak up a little bit. After resulting in death or battery, the state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you do not need to agree on which one.
But you are not required to agree as to which crime was committed. And then the language will continue. The crimes of, all of them will be listed, have been defined for you. The remaining part of the instruction remains. Again, I'll give this to the parties. It's been another long afternoon. It can be a little hard to follow these things, even when they're in front of you, as you can see. There are 68 pages of instructions. I think it's reasonable to have these all printed off and give Mr. Brooks and the state one more opportunity to review them for final consideration first thing in the morning.
Just so I understand for the record, the jury instructions that you have are the ones that we're gonna use. I can't make a few of my own.
You can still, if you want to draft something, you have to submit it so that we can consider it, but it has to be in writing. And keep in mind, sir, jury instructions are read by the court, and they're statements of the law that I give to the jury so that they better understand their functions as a juror and the law that applies to this case.
Thank you, Kathy, for the
But you have until
$5.
tomorrow morning to bring that to court in written form. If it's accepted by the court, my clerk will type it up and will insert it in the appropriate spot. If it's not accepted, then it won't be included. But as to what we specifically have before, everything but the bail jumping, element 3.
Why? Why? Twice? What the fuck?
Okay?
Why did you do it twice?
Or are you just stating an objection that
They
you don't
said,
consent? Which
smiley
I'll note for
face.
the record if that's the case.
Well, it's still the same that I said before.
Okay.
At this point, I don't see why. I guess essentially what I'm saying is if
Why did you do it twice?
raised before, and there's been ample time, at least for the prosecution, to review the questionnaires, or not the questionnaires, I'm sorry, the jury instructions. What prompted the change now, all of a sudden?
Because this is the time in the proceedings for the court to finalize those and to address any modifications. That's standard protocol.
So I'm still,
Thank you, Sarthal, for
Objection
the
is noted, sir.
$100 super chat.
I am approving everything that's in there. The parties will still have an opportunity to look at the change to the jury instruction on bail jumping. Mr. Brooks will still have an opportunity to submit any additional proposed instructions tomorrow morning, but at least we have this packet that's been approved, again, with the one exception on the bail jumping charge under element 3.
it has to be in writing, just so I understand, everything's in writing.
It does have to be in writing, sir. That is a requirement.
So is it, would that be in a form of a motion or just a simple writing? I don't understand.
Sir, you can simply submit proposed jury instruction. Okay?
Y'all are evil.
But it does need to be in writing because that's how I will need to review it.
I need to fix this. Why did it do it twice?
I'm just, like I said, I'm just trying to understand what what it needs to be written up as a motion or just a simple writing.
It can be a simple writing. You don't have to put a motion. I'm allowing you to submit a proposed jury instruction or instructions, I guess, if that's your choice. I don't know what you have in mind, but you can submit those tomorrow.
Yeah, I didn't have any, I just wanted simple clarification, that was all.
I appreciate
don't
you seeking
understand,
that.
So,
All right. As to my list, other than the motion for reconsideration, did I overlook anything?
I don't know if you want to discuss exhibits, Your Honor, and I did want to say for the record, we did file what we have currently is 8 pages of exhibits, numbered 1 through 140. It's a combination of videos, photographs, and documents. I did have that 8-page list hand-delivered to Mr. Brooks earlier by Detective Reglin. That's one of the documents that he's stated he will decline to accept. However, it's an important document and one that he would be well-served to read. In addition to that, Your Honor, we've had all 140 of our exhibits saved to a thumb drive, and Detective Reglin hand-delivered that to Jail Administrator Wollenhoff this afternoon, so that if Mr. Brooks wants to look at our exhibits tonight, he can do so. He just has to ask the correctional officers for that thumb drive with the exhibits on it, and he can see all 140 exhibits that we've prepared so far, and have a very good indication of some of the evidence that will be presented against him during the trial. I do have a question, Your Honor. I understand from the court's order about you want digital exhibits. We have some physical evidence, not a lot. We have some physical evidence that we're going to, and it's later in the trial, so we don't necessarily have to talk about it tonight, but I want to put the court on notice. Our standard routine of presenting it to the witness on the witness stand, we'll have to work around that. We have some large poster boards that we have prepared that
Like demonstrative exhibits or something?
Yes, maps. And we had those prepared, weeks ago before we got the court's order. Frankly, and I know the court's aware of this, but it's going to challenge the prosecutors greatly by our inability to move around the courtroom, and I understand the reason, but I just want to put that on the record. We are wondering, as far as the exhibits, our paralegals prepared to present them all from our table, but specifically for like photographs and documents, should we print out a copy and have that marked and received so that if the jury wants it during their deliberations, they have a printed copy? I understand with videos that won't work, but photographs and documents that may work.
I have had that done in other trials where even though it's been presented electronically, the attorney has also submitted that paper for photographs, exhibit, things of that nature, so that it's available if needed for the jury. And I think that's fine. I certainly would approve of that. We also have the ability, when the jury is deliberating, to present any electronic evidence directly to the jury room. We would all see it in this courtroom. So if it's videos that are playing, if they request a video, that's how that would be done. But even if it's a succession of photographs, that can be done, or even other exhibits, like paper exhibits, things of that nature. I personally prefer that there are the photographic copies and paper exhibits as well that have the numbers, and those are the actual exhibits, but what you're displaying is obviously a replicate of that.
Okay, so we will do that for photographs and documents. Obviously, the videos we can't. Can we burn all of our exhibits onto one thumb drive then and have that essentially entered into the court record?
I don't have any objection to that.
Okay.
CCAP might have another position on that, but that's okay.
Oh, way to screw over the IT guys, Judge. Jeez.
And then, as to opening statements, I understand the court's order. You want us at our tables. Would the court reconsider that in the event Mr. Brooks is not present in this courtroom for the state's presentation of opening?
At this time, I would not reconsider because, as you know, I oftentimes invite him back in or require him to come back in, and I don't want to be in a situation where now I've let you do that, but I can't let him do that for what I think are obvious reasons to
Oh,
everyone.
I see, okay.
So,
But we can stand up at our table during
You
openings.
can stand up, yes.
And he can too.
He can stand up as well.
Okay,
Yeah,
okay.
but no podiums. I can address poster boards and physical evidence. I will make an exception to approaching witnesses for those types of things because it's a limited exception to my rule, and I wouldn't, how else would you be able to do that, right? I mean, the poster boards, you might have those electronically in some other format that you could use. You might want to use the annotation. Just for the record, Mr. Brooks is handing up the objection sign. We're just talking generally about procedure. There's no exhibit or to specifically object to. I'm not sure if you're objecting to procedure, but I'll get to that in a moment. Certainly physical evidence, you need to make certain, there needs to be certain foundational testimony. They're going to need to see those pieces of physical evidence. I understand that.
Okay.
Anything else?
No, that's it, thank you.
Mr. Brooks, you raised an objection, or?
Well, yeah, because I didn't want to have to try to write something and then have to send it over there. I really was raising it so you would know I wanted to say something, but still not interrupt. Just so I understand, what the prosecution is saying by burning the exhibits onto the flash drive and then admitting them into the record, is that then essentially when things will be admitted into evidence? Because I had that issue yesterday when I asked that question, because I have exhibits too, and I have some things that I would like to offer into evidence as well.
So I'm not talking about like admitting things with specificity at this moment. I'm talking about some procedures. I'm trying to frankly be mindful that you're in custody, sir, and that even though when you appear before the jury, you're dressed in civilian clothing, like the suit that you wore the other day, but I am taking steps to ensure they don't see the restraints that are on your ankles. And because you have that physical limitation, I now am adding or have added a limitation to the state on, for the most part, physical movement within this courtroom. That's why there's no podium. They're not going to make opening statements or closing arguments from a podium. It's really to, in my words, level the playing field, if you will, and to ensure that as the parties appear before the jury, It's on as level of a playing field as I can provide. So if you have documents, we have a thing called a document camera, and so it will be in use. It may require the assistance of the bailiff, because my understanding is, and we can talk internally to find out if I need to have court staff, whatever. My understanding is it has to be on the state's table. I'm not sure where it went. It's usually been there. And so it's possible, we'll find it. It's possible.
It's me. I moved it.
Okay, it's been moved. We'll put it back, but it has to go on the state's table. So if you have a document, sir, it might require you to pass it to someone who then puts it under the document camera, and assuming the witness, it's appropriate, meets the rules of evidence, it can be authenticated, there's a proper foundation, etc. And if I receive it, once you hear the phrase, the exhibit's received by the court, that's when it becomes an exhibit that the jury then can use.
Yep.
Does that answer your question?
Not really.
In one ear and out the other.
I'm sorry, Your Honor.
That's okay.
I think what I was referring to more as, for things to be able to be offered into evidence. So was that?
I can, Kidro. I forgot to do that.
I apologize.
Do you have the exhibits? Are they paper? Are they electronic? Are they something else?
Well, I'm sure the majority of them would be papers.
So sometimes there's something in the discovery that's electronic that a defendant wants to use at trial. And I have typically asked the state for assistance because they have all of that. At least that would be my understanding. If there's something specific, though, and they have it, you should let them know. I don't need to be involved in that conversation per se, but you could write out for them what it is, and then I'm sure they can make arrangements to display it, and so it's presented to a witness if appropriate. Go ahead.
Would I write that out? Would that be like an in-court thing? Because that's obviously the only time I would see the prosecution.
Well, sure. You would write it while you're in your cell, when you're in the conference room reviewing things, and just make some notes on what it is. And then tomorrow morning or whatever day of trial, if you think you're going to want something and it's not on their exhibit list, you just make a note and we'll see if they cannot make arrangements during the trial to display that. I'm not speaking on whether anything's admissible at this point or not. I'm just talking procedure.
Okay. I'm not sure about that. Well, the statement, the sentence before the last one, with the exhibits, they have to be separate exhibits. The prosecution has their own exhibits, and I have my own, so that way we're not using each other's exhibits. At least that's what I took from.
Yes, but if you're going to use an exhibit
Mazel tov.
that the
to make
state's
sure that it's not one that they're not.
right, if they have something on an exhibit list that you want
Oh
to
my
use,
God.
it's pretty standard that we only use one copy of whatever it is, and then you're able to use that once during your case because it's already been admitted. Hopefully that helps answer your question.
Yeah, that helps.
Okay. Anything else?
No, we did want to indicate that certainly we're willing to share exhibits with Mr. Brooks. If there's anything he wants displayed and it's admitted by the court, we can pull it up and be of assistance to the court and Mr. Brooks. We also want to renew our earlier offer if he needs assistance in serving subpoenas, as long as it's a relevant witness and it's a reasonable request that is limited to southeastern Wisconsin. We will give any assistance we can. We want Mr. Brooks to have a fair trial. We want him to have his relevant witnesses and evidence ready for the court. If there's something he wants, even if it's a document, we don't have the document camera, we have the entire file scanned, or he can give it to us and we can scan it in 1 minute and have it up on the screen. So we are more than willing to do that so that we can all be efficient in our presentation.
Thank you. Did you hear that, Mr. Brooks?
The prosecution wants this to go as smoothly as
So,
possible to make sure that he never gets out of prison and this doesn't
No, go
become a
ahead.
mistrial or overturn on appeal. They're doing everything they're trying to do to make sure that he does not get a mistrial or be overturned on
That's
appeal.
one thing about the subpoenas.
So the sooner you can fill those out and get them to, I can copy them for you so that the state has them and give you a copy. We'll facilitate that, right? I know you're gonna wanna keep a copy of whatever it is, but the sooner you can bring that information to court, that would be the easiest and most efficient way to get that information to the state, meaning you gotta fill out your subpoena forms and then give them to the state, who will then look at them and they'll be able to tell you yes, no, and we'll go from there, okay?
So I'm not asking for legal advice, but it would greatly benefit me if I'm able to know that I'm filling out the subpoenas correctly.
No, fuck you.
I'm able to review for completeness, so if you bring them to court, I can at least do that.
Okay, because the last thing I want to do is write all these subpoenas up and then bring them in and they're incorrect, or something is not done the way it should be done.
I can review for completeness, and we can go from there.
And Your Honor, I just wanted to correct one statement I made before. I had indicated that the jury instructions would be available on the computer in the conference room. That is not correct. They would be available in Lexis, which I believe is on his tablet.
Do you have Lexis on the tablet?
I'm sure I can find it. I wanted to say too, it's not my tablet. They're for use from everybody, so I don't have my own specific tablet.
Understood. Lexis is a legal research, legal material platform.
Yeah, it
That's
is.
what I use, so I know it to be very thorough, but you have to search for things, but I'm told that the jury instructions are available through Lexis, through the tablet.
Yeah, I don't know exactly what the program is called itself. It just goes by the law library. That's what we all
Okay.
call it. So,
All right. Is there anything else, Mr. Brooks?
no.
Okay, then that leaves tomorrow morning just the finalization of the jury instructions and the motion for reconsideration.
Yes.
Okay.
Oh my God.
Thank you, everyone. We are in recess for tonight. We'll see everyone tomorrow at 8:30 a.m.
Is it over?
But let him know I'm gonna print it right now, so.
It's finally over.
Yep, and the bailiffs need to make sure they don't let, we need to print off material for him. It's coming forthwith. All right, thank you. We're in recess.
Polycom's on.
God damn. Oh. Oh my God, that was pain. Holy hell. So there are a couple of clips though that we got at the Law and Crime Network took out some of the more heated instances. So we're gonna go through some of those clips now.
So I'm not
But I-
arguing it with you,
I
sir,
know, I
one
just
bit.
want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent.
I do not consent.
Let me-
or
let
agree
me-
to
Drink.
being cut off right when I'm trying
All right,
to
I'm just
provide
gonna
the
talk
court with
over him for a
information.
minute. I do not have any other information regarding the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request, because the jail has not provided me with any specific information regarding the reason you were placed on protocol, whether you were exposed, whether you are showing symptoms. They cannot provide me with that information absent you giving them permission by signing an applicable authorization to do that. Without that, I have to rely upon you to provide that information to me if you so choose.
That is incorrect, because just yesterday you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here to have me verify that they can go in my cell and search for that. So I find it very
I have
hard
no
to
idea.
believe that you can't consult with jail staff,
Gary,
to tell you what is going on in my situation, where they know that I've just been seen by a nurse that placed me on this protocol for having
shut up, Hope.
a loss of taste, fatigue, and I have to wait for the results
no,
of my
Taze,
test. And until
no.
then, I am on a protocol which restricts me to my cell. That is very easy information to obtain, and I find it very hard that Your Honor cannot obtain that information, but can obtain a way to communicate with jail staff when there's a witness list involved. We're talking about someone's health that can affect not just you.
So if you guys weren't keen on what was going on earlier, Brooks filed a motion to adjourn based on the idea that he may have COVID. And so he wanted to adjourn. He had taken a test, but the results wouldn't come back until Friday. So, but the judge and the prosecution are like, no, we could just simply adhere to proper COVID-19 protocols. There's no reason to adjourn or delay the trial.
But anybody else, not just officers, but also inmates. We're talking about health and we're talking about safety. That has a lot of merit. And frankly, Your Honor, I'm afraid. I'm fully vaccinated and I've never had COVID. I don't know what I'm looking at here. That was the last thing I was hoping I would be told today, Your Honor. So I'm afraid right now. I'm not feeling well.
I honestly think he's full of shit, but that's just me.
Reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip.
In some states, it's automatic, Ed. I don't know if that's the case here in Wisconsin.
Nurses, that is the reason why the COVID test was administered, and that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done? Again, I cannot obtain that information on my own.
I'm not a nurse, Your Honor. I don't know the name of the test. Like I said, I've never had this happen.
Let me clarify that. That was a pretty ambiguous question. So, you reported symptoms as that's what you're telling me, right?
Correct.
And you're saying some tests were done?
I mean, it's obvious. I mean, why can't it be verified with the nurse?
I have to verify it with you. The nurse will not provide me with this information.
HIPAA, bitch. HIPAA. The nurse isn't going to tell you that. Or tell the judge that, you dumb. Oh, my God.
But the jail can, because they control the movement.
Oh, my God.
They control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the moment.
It's not, but I'm saying, how can I tell you, how can I answer what you're asking me? It doesn't make sense. We all understand that the jail itself controls the movement of the inmates. That's common sense, Your Honor.
Oh my fucking God.
Here to talk about inmate movement at the moment. What I'm asking you is, do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
Well, then why didn't you answer the question?
Do you know what type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
All right. Do you know when the results of that test will be back?
From my understanding, Friday. That's what I was told by the doctors. I would have to be at least on this protocol until the results come back, which
Were you-
he said the earliest would be Friday.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them.
If one can be obtained, are you willing to submit to a rapid test?
I'm not willing to submit to anything right now until we take care of the issues that's at hand. I mean, I've already been placed on the protocol. Frankly, I'm very afraid right now because I don't know what's going on. This is new to me. Like I said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021.
Okay.
And so I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor. That's the reason why I submitted the ICF for the adjournment. I was thinking at least until I can get the results, at bare minimum. I don't think I'm asking something that's
Sir,
impossible for
if
Your
I
Honor to
can
grant.
make arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at this time.
Why not?
Because if I do that, I won't be able to stall the proceedings. That's why he doesn't want to do a rapid test.
Not at this time.
Why not?
Why can't I get the results for the test I already took?
But you're telling me you're scared? You're
Yes,
fearful?
I am.
But you
am
don't
very.
want to take a test that might
I
tell
took
you today?
I took the test that he gave me. If
You're
he
telling
felt-
me that test result won't be available to you until at least Friday.
At least Friday, that's what I was
So
told.
tomorrow.
I was told that I would be
Sorry,
placed
day
on this
after.
protocol until the results came back. The earliest that the results would be back would be Friday.
So that sounds like, to me, I think that's what they call a PCR.
Oh, Arian Rada, we
have
just
no idea.
finished watching it.
I have no idea what it's called. Like
Let
I
me
said,
ask
I've
you-
never had COVID. I don't know the test names. I don't know what they call them.
I'm generally familiar with some of the testing for COVID. There are tests that can be what we call rapid tests, or what are called rapid tests, that are available. And then there's these other tests which take a few days. Again, I'm not a scientist, but I think the general belief would be sometimes the rapid tests are accurate, sometimes they're not. Sometimes people test negative when they're really positive. It just kind of depends on the circumstances. But it's my understanding a positive test would be pretty accurate. And then there's other tests that take a few days for the results to come back. It really depends on the lab that's being utilized, etc. I'm asking you once again, if a rapid test can be obtained, are you willing to take a rapid test?
How would that be obtained? How would it be obtained?
I would
was
work
told,
with-
I can only go by what was told to me, because when I was brought in there and they told me that they had to test me for COVID, I was immediately like, what do you mean you have to even test me for this? What is this about?
Well,
I had
didn't
a
you
lieutenant.
report symptoms to them?
Excuse me, Your Honor. I had a lieutenant and 2 officers present when I was asking all these questions. Why do I need? What's going on with this? Why is this? Why is this? Why is that? Because I didn't understand. Immediately in my head, I started to get afraid when they said they had to even test for COVID.
Well, were you reporting being sick and symptoms prior to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue, with me feeling very fatigued. And I said, man, I don't know if it's just me being tired, or that's what I initially thought it was. Maybe I'm just a little exhausted. But I said, no, anybody knows their body. I said, this got to be something more, because I'm really, I don't even have an appetite. Then when I'm trying to eat, I can't taste anything. That's what said, okay, now I need to put the medical sick
When did
card
you
slip in.
report these symptoms to the medical people, or to even just a correctional officer?
A few days ago. Over the weekend is when I started to notice the fatigue. So usually I don't just jump the gun and say something's wrong, because it could be anything. So
When did you report the loss of taste?
I reported the loss of taste last night.
And was it after that they told you they wanted to test you?
No, they didn't tell me till this
Channel
morning that
merch?
they wanted to test me.
Big dude, I need
What other
people with
symptoms,
creativity
are you-
to make some merch for me. I have no fucking creativity at all.
That was it so far, just the fatigue.
I keep forgetting to do that. Eventually I'll get around to it to have like a t-shirt or a mug or something.
Which is the reason why I was told that I had to take the test.
I need an artist, let's put it that way.
Which I was told at that time also that the earliest my results would be back would be Friday.
And you said.
And
at
no,
this point
it's
you're
not gonna have
willing to
feet
take a rapid
pics.
test.
Well, they said this is the test that they do. The nurse was very resolute. He specifically told me that this jail, this is the test that they do. They do not do rapid tests. I didn't even ask about the test because I know nothing about the test. This is what I was told. And after he told me that, I said, okay.
Bunker
fine,
branding?
do the test.
That's a good
and
idea.
I'll just sit on the protocol because at first when he told me, you know, you're going to have to be on a protocol where you're isolated.
I think Omega, I think I was drunk when I
said,
wrote
okay,
that down.
fine, Just do the test. I'd rather.
But I remember
do
that
the
now.
test and make sure that I'm healthy than to just refuse the test and just say, I'll just wait to see if I get better or something like that. So I said, yeah, just go ahead. And that's what I was informed. Friday would be the earliest that I would get the results back. And I would be placed on a protocol which is called isolation, where I'm not allowed out of my cell.
Oh, bunker is very pricey.
Anything else, sir, you think I need to know about this issue as I consider?
Charlie?
your request?
Really? I'll have to reach out to him.
At this time, I'm just telling you what I know. Now, like I said, Lieutenant Chamberlain was there. 2 officers were there.
Any objection if I talk to any of them to confirm what you're saying?
Absolutely not.
Any objection if I need to ask the jail administrator about, or anyone else at the jail about the protocols and what's available for testing?
Absolutely not.
Given any information about whether anyone else in the facility is experiencing COVID right now?
I wouldn't know that. I wouldn't know who. I'm in the midst of
$49 a shirt?
medical pod as
Holy
it is.
shit. Yeah, no, fuck
No
that.
information's been provided to you that there's like either a lockdown or some type of a restriction due to any like concern over COVID at this time?
I would never have that information because, like I said, I'm limited in the pod that I'm in. I have no interaction with any other inmates, and my interaction with staff is pretty limited.
For employees, I fully recognize being in a correctional facility, and inmates are, of course, or can be very close to one another, and so.
All right, I'm done with this. They're talking about fucking protocol and bullshit. Where was it? Oh. They have posted this. This is the Ring doorbell cam of when Brooks was arrested. If you guys recall, he was somehow able to get away from the cops, ditched the vehicle, and was arrested at somebody's residence trying to ask for help. And this is the Ring doorbell footage from that.
Hey, I called an Uber and I'm supposed to be waiting for it over
Thanks,
here,
Dave.
but I don't know when it's coming. Can you call it for me, please? I'm homeless. I don't know. It's might be him. Oh, yeah, for sure. Yeah. That's My ID.
Those are the cops right there. Oh, here's where the prosecutor calls him out on this motion. This is where the prosecution calls him out on his motion to adjourn, I think.
Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks. I can advise the court, as an officer of the court and as an offer of proof, that he is.
How could
Mr.
that?
Brooks, did
How
you
could
hear
that even?
Attorney Opper interrupt you when you were talking?
Well, I respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond. I'd
That's
encourage you to use
that is
paper and a
ridiculous, Your
pen
Honor.
to write down. That's the rules of decorum in the courtroom, sir. We generally avoid interrupting one another so that, number one, the record can be clear, and perhaps most importantly, because that is a sign that we all understand that this is a place of dignity, it is a place of respect. It demonstrates that, frankly, a willingness on the participants to conduct themselves appropriately. It avoids creating disorder or disruption. So I will give you an opportunity to respond, but you need to give Attorney Opper an opportunity without interruption. Go ahead, Attorney Opper.
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the defendant's behavior since about the August 25th or 26th.
Ginger Cat's
motion
Pale Ale.
hearing.
Ah.
I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or adjourned or pushed back. This behavior, again, on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information. I believe Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. And also, I believe she would be able to provide information if the court ordered her to do so.
So basically, she's just said, this dumbass admitted in recorded prison phone calls that he intended on delaying the proceedings.
Jail cell.
Yes, ma'am, to the best of my knowledge.
Okay.
I object to
Is
that,
he
Your-
still
I object
able-
to that, Your Honor. I'm not allowed
Sir,
to
her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity.
Will she?
Your
will she be able
objection
to-
is
Will she
overruled.
be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't.
More than enough.
I am turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object, just like she objected
And-
when I was asking
Right,
questions.
and when the court rules on an objection, usually the party who objects stays silent. I rule on the objection. The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms.
rather,
Molenhop.
that you are making.
While on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials. Is that correct?
Correct, ma'am.
And you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
So, an objection goes to whether there's lots of rules of evidence that
That's it.
apply, but if you're objecting to her answer, that's a different thing. You can
I'm-
argue
I'm
the meaning
objecting
of
to
that
the
language.
question,
Okay,
not
the
the
objection,
answer.
but then you have to say objection before she answers. You
She
objected
didn't
after
answer.
she
She
answered.
didn't answer the last
The
question.
objection is noted, it's overruled, her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail,
I
correct?
respectfully object to that.
Overruled, she may answer.
Correct. He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled, you may answer.
Correct, ma'am. And
So you're gonna
the proto-
overrule everything, Your Honor?
All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It
see
has
it.
the criminal statutes.
I don't see it.
It has the traffic code. It
I
has the
don't see
rules
it.
of evidence. Well, it's on your table. It's
That- I
behind the
don't-
microphone, and it's there. I've provided it to you as a courtesy so that you have that
You
available
did not
to
provide
you.
anything to me.
All right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
may
to the
have-
other courtroom.
something
I've
that-
provided ample
I've
opportunity
never-
for Mr.
I've
Brooks
never
to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your lack of
don't give
consent is
consent.
noted for the
I
record.
don't give consent to an estoppel. I don't
I'll
give
make a
consent.
more full record when we
I
are
don't give
open
consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam
being
Reporter, the
able
record
to
should reflect
exercise my
the court is
constitutional
stepping
right.
off the bench. You may step off.
I
if you
move.
want
I
to
move
remain.
for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
Oh, this fucking guy. Yeah, he's a fucking idiot. Ugh.
Decision making and put my findings on the record, but his behavior started very early on. I gave him ample opportunity to abide by the rules of decorum. I gave him ample warning before he was removed. Objection! This court, frankly, has no other option at this point other than to put him in the other courtroom so that I can continue with this very important hearing, a hearing at which he has requested an adjournment of the proceedings. With that, I will turn back to Attorney Opper. I am going to unmute Mr. Brooks, but also advise him that if he interrupts Attorney Opper or others as they are providing testimony here today, I understand he can object. However, my expectation for that objection process would be that he say, I object. He provide a basis. Objection! Oftentimes give me one word. Is it hearsay? Is it, calls for speculation? Is it irrelevant? Whatever it may be, a very either 1-2 word objection or a very short summary statement of the basis for his objection. After he does that, I will rule on the objection, and I expect him to honor the ruling that I have made. If he can't do any of that, he will remain muted, and the process will then be...
Jury selection has already been done.
Sign. He's holding it up right now, demonstrating for us. He has the objection sign. He will be required to write down his objections on a piece of paper that will be provided to the bailiff. The bailiff will provide it to me, and then I can rule on those, even if it's striking testimony later on. I do expect his objections to be based in law. I note, was provided with the copy of, it's a selected statutes, including the rules of evidence. All right, go ahead, Attorney Opper. For the record, the mute has been undone.
Thank you. So, Ms. Wollenhop, I was asking you about the digital discovery materials You testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing
Hold on
about...
a second. Mr. Brooks, the basis for your objection at this time?
That is irrelevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize the conference room or a tablet.
Your objection is noted. It's overruled. Her answers may stand. Next, you may continue, Attorney Opera, with your next question.
The nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer. Yes, ma'am.
And there would be nothing that would restrict his ability to come to court.
All right, I'm not gonna do that every single freaking time because he's going to object to every single fucking question from here on out.
Correct, ma'am.
And when he comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that correct?
Objection.
Overruled. Correct, ma'am.
And in fact, there's a card available for him to do that if he so requests.
Objection.
Oh my god.
That is correct, ma'am. Correctional officers would transport it, but yes, there's a card available.
Sure. Mr. Brooks had told this court earlier that he started
Maybe a shirt with a
not
play on
well, I believe,
Phoenix
when he
Wright
was
objection,
over the
but
weekend.
instead of Phoenix,
And,
it's like Archer or
is there
Winston on it. Maybe I can
notice
commission
to
that.
any correctional officer or jail supervisor that you're aware of that Mr. Brooks reported that to them?
Objection.
Overruled.
I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or a lieutenant,
Hold on a second. Was that an objection? Or just a...
No, he was talking underneath his breath because he's an asshole.
Your objection's noted. It's overruled.
This fucking guy.
if he were to complain of illness to a correctional officer or a lieutenant, would they?
I think there's one last clip.
Your Honor, may I state something?
And then there's something that I
Respond. Go ahead.
there's actually two videos I want to show you. One was sent to me by a viewer, one was sent to me by Danny.
One of the detectives that is sitting right behind the prosecutor's desk right now, Detective Casey, just went through something similar with COVID and was not present for a couple of hearings. I don't know how long his protocol was. I can't speak to that situation. It's not my business, frankly. But he wasn't present in the courtroom, and I think that has relevancy due to probably him feeling the same way, not wanting to infect anyone else or put anyone else at risk. I don't see where there's any difference in my situation. Also, very briefly, for the record, I was able to make a phone call. Phone call attempts, because they were attempts, this morning after I came from getting the test because I raised the issue. I said, since I know that I'm going on this protocol and I'm already out of my cell, can I take this opportunity to try to notify my family of what's going on? That's why there were so many attempts, because I wasn't able to reach my mother.
Dude, if I drank for every objection, I'd be dead on stream.
She has access to my kids.
And then my channel would be banned for toss.
To my children. She's the one that is in charge of all that. So I just wanted to state that for the record.
Thank you, Mr. Brooks. Well, the court has heard from
Shut
Mr.
up, Gary.
Brooks. court has heard from
Silence.
the jail administrator. The DA has provided some additional information as officer of the court. Let me address Mr. Brooks' motion to adjourn. He filed an inmate communication form earlier today, raising this issue. He is on a protocol. He is not tested positive. He provided information today that he is
From
fully
what,
vaccinated.
Charlie? I don't know what you're asking.
That he'd been telling officers for days that he had not been feeling well. We do not have the test results today. He was offered a rapid test and refused. He reports symptoms of fatigue and that he can't taste. He also indicated it was a few days ago over the weekend that he started experiencing these symptoms. Now, during his time here today, Mr. Brooks, despite the disruptions, has been very clear, coherent. He has asked questions. He's made objections. I know he might not like the word argument, but that's a word that we use in the adversarial system when the court asks the parties for their positions on certain issues. We call it legal arguments, or arguments for short. Doesn't mean or have any connotation that it's unruly or disruptive or a disagreement. It's just the word that we use in the legal system. He was able to articulate his positions to the court. He at times appeared animated. He appeared, again, to understand what the court's either questions that the court was posing to him or information the court was providing to him. He clearly was able to Mr. Brooks,
Muted.
please don't interrupt me or I will mute you.
Well, I thought she did mute him at that moment, though.
He was able to follow the questioning and answering process with the one witness who is here today. I appreciate that he clarified that he was not making this request due to trial prep or access to material issues, but it is really related to his health and safety concerns. At this point, there's insufficient information on the record to find that his concerns are anything more than speculative. And given my observations here in court today, he is very able to assist in his own defense. He's able to present arguments, etc. I've already noted. We are able to accommodate the health and safety concerns in this courtroom. We confirmed that where he sits at the table, if he's in this courtroom, there is no one around him who would be within 6 feet. That is an important consideration that has been one of the topics of guidance from the CDC, certainly one of the, or part of the guidance we have received from the county. The most recent county protocol talks about isolation for 5 days. Clearly, if he had the onset of symptoms over the weekend, which is what he reported, and he has not had any escalation in those symptoms, as has been demonstrated by his ability to participate in this hearing. The court will find that there are no present health and safety concerns other than what I've noted with the 6 feet and social distancing. I'm not going to adjourn this trial. I'd also
Shocker. She's not going to buy into his bullshit.
put on the record that he has not been denied access to materials. He has full access even with this protocol. He has had access even to the phone. There's been what's been referenced by both the state and Mr. Brooks about attempted phone calls. I'm not so concerned about whether phone calls go through. It's the fact that he's been given access. Whether he connects with someone is not the issue. I'm directly about that. If he were truly concerned about his own health and safety, he would want to know immediately.
Yeah.
He repeatedly would
But
not answer that question.
He refused to want to get
wanted to debate about
He didn't want to get a
what
rapid
was
test.
provided to him and why perhaps it was not. All right, you're interrupting me. I'm going to mute you. So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic, given the information that this court, and once again, on the record before me, there is nothing to suggest that he is actively being impacted by COVID-19, and that any health and safety concerns he has for his own safety can again be met. The jail's able to get him here. The jail, of course, is responsible for his medical care. We can keep him 6 feet away from any other person. Obviously, if he's removed to the other courtroom, that provides a greater buffer as well. And
All right, so we're gonna go through some these other two videos before we close out. This one is from Judge Simpson.
Very brief on that. We had a few breaks during, I think what my client is getting to, we had a few breaks during that time.
I can't even hear it. I can't even hear it. This is Nazi. This is Russia. I can't even hear what the prosecutor or my attorney are saying.
Mr. Marshall Brown was allowed to leave his stand.
Wait.
And if you don't want me,
oh, I think I missed it.
Is because
he is here.
Okay.
He's claiming that he's not going to come in because it's on Zoom.
and my attorney advised me that if I didn't have a preliminary, that not to do it on Zoom. So.
Well, so that the record is clear, I had removed this defendant from the courtroom, had advised counsel that we would be proceeding by Zoom. So he's going to have to make a choice of the choices I gave you, Mr. Kill. And that is that he can either decline to participate and we will proceed, or he can participate by Zoom. Those are his options.
So I can speak. So can I speak?
Go ahead.
If you want to, Mr. Bloom.
Mr. Simpson.
That's Judge Simpson.
That's Judge Simpson to you, sir.
Your Honor, I don't have to be on camera. I refuse to be on camera because Mr. Kilwald, I don't mean any disrespect, Your Honor. I think you're a highly
Hmm.
efficient, very intelligent judge that has been around here a long time. And as well as you know, I have. My qualm with this is because Zoom, at the last hearing, Zoom was broadcast over the internet where the other victim and witnesses that weren't at the court weren't sequestered like was supposed to be. And it was on Zoom, which I'm aware there isn't an MCL number yet, but I'm sure within a year or two, there will be something precedent to where it's not allowed anyway, because I asked for a in-person sequestered witnesses and that didn't happen. That I was violated. My rights were violated. I feel my rights were violated. And my attorney this time, I don't mean to take up time. Your Honor, I have anxiety and I've been really stressed out because as will be shown in the long run, no matter how many felonies I've got, no matter how many times I've been to prison, I will be exonerated from these crimes. There's no doubt in my mind.
Naturally.
And I believe, honestly, that the reason that the victim did not, or the second victim, supposed victim, didn't show up for court and said she had a COVID, positive COVID, is because a crooked doctor in Ipsy gave her a positive COVID because she's on drugs and alcohol because she gets $2,200 a month and she's very addicted. She's very strung out.
What does this have anything to do with the current circumstances right now? The fuck?
She cut her tether off. They're not making her get treatment. They know she drinks a half gallon of vodka every day.
Okay, so
Jeffrey, this is your attorney.
Okay, all right, I'm done talking about that. What I have to say, Your Honor, like I said, I've got the utmost respect, and I've heard you are a very fair judge, very qualified to do your job, and that you have seen through the crack, okay? And you know what goes on in Ipsy, and you know what's going on in them streets. So I'm letting you know now, though, that as my attorney said to you, I will be perfectly fine if you allow me to come back into the courtroom. But he advised me that maybe I shouldn't do this on Zoom. And I do feel myself that yes, I made a mistake. But like I said last time, I was put on Zoom when I wasn't even aware until I was kicked out of the courtroom that I was on Zoom. And that the witnesses were able to leave the courtroom and go out and talk to the other witnesses and pull up Zoom when they get home and show them, this is what I said. Now you need to follow along with this. Then you got the police officers going to arrest her.
Mr. Bloom, you don't know any of what you're saying even happened.
I don't?
No.
I don't.
Nope.
Mr. Kilowald informed me.
Jeffrey, this is your attorney. Please stop talking. You're just making matters worse.
Okay, well, Mr. Kilowald, I put things in your hands. And
I'm going to ask the judge if we could do this hearing without Zoom. That's the judge's discretion.
And I said to the judge, Your Honor, I promise you, I will be cordial. I will be polite. I will not. I had a cold last time, so I did make a couple little snide remarks or whatever. And maybe it was your discretion. So, but the thing is, Your Honor, I don't mean to carry on, but use your judgment, Your Honor. And if you don't want me to be there, I have trust in my attorney that he will get the copy of the COVID test. He will get all the evidence needed to show that this victim did not show up for court because she does not want to show up for court, whether the police went and got her or not.
Mr. Bloom. From my understanding, although I have not heard from them yet because we were waiting for you to get here, there's an officer here who arrived to get the victim in this case.
Supposed victim.
And
he didn't use allegedly previously though. If you recall, he didn't have a qualifier of allegedly, but now he wants to put in supposed victim.
No, he arrived to do that.
To get a supposed victim, not a victim.
God damn it.
Okay. I've listened to you talk without interruption, and now you're listening to me.
Yes, sir. Yes, Your Honor.
And the officer saw the COVID test, from my understanding.
Did he take a picture?
I don't really care whether he took a picture.
I don't give a fuck.
If he's going to tell me that that's what he saw, that's what he saw.
Okay.
And so that's not going to happen today. The other case that you're here on is prepared to go. Now, you can elect to participate or not, but I think you need to understand something very clearly, Mr. Bloom. You do not make the rules. You will not sit here and say that somebody is violating your rights, that I guess being me.
In this courtroom,
some type
I'm
of
God.
extortion to get your way.
I'm the captain.
Wrong judge, wrong day, because it doesn't happen with me.
Well, I'm sorry you see it like that.
Plain and simple.
I'm sorry you see it like that, but that's not what I'm trying to articulate to you. Not at all.
So I just asked, and these are the rules that were set because they were set because of Mr. Bloom's behavior. So I will again pose the question as to whether or not Mr. Bloom wishes to participate. he doesn't wish to participate, he doesn't have to participate. That's his call.
Your Honor,
But my intent would be to go forward.
Your Honor, on behalf of my client, again, you've heard him say that he apologized, Your Honor. He would like to be present in the courtroom. I would ask the judge to reconsider, I believe, and relocate it. If not, I would ask that it not be broadcast on Zoom, which again penalizes my client, but I don't know what else to do.
I am not going to deviate for anyone from what
Ooh.
has been this court's procedure. It will broadcast on Zoom. If necessary, it will proceed, or it will broadcast on YouTube. It will proceed.
Really?
Just please note my objection to my client.
I've noted your objection. I saw the email that was sent indicating that your client requested that the courtroom be closed without any
Nice,
statutory
Sean.
authority whatsoever to close the courtroom.
Your Honor, you're allowing
And
the
that-
witnesses and the victims to see each other's testimony on Zoom. You're allowing witnesses and victims to see each other's testimony.
Your Honor, to Ms. Reiser's credit,
With-
I believe she did cite a court statute that would allow you at your discretion to close.
And my discretion doesn't mean that I will, and I'm not closing the courtroom.
Ooh.
I'm
Well,
not.
then you're corrupt. You are in violation.
Oh.
Oh, that's it. You're in contempt. That'd be 93 days.
Look at him. Look at his attorney's face with his hands in his face. I missed that part. The attorney has his hand is like fucking face palming. It's like, oh fuck, god damn it.
Anything else you want to say, Mr. Blue?
Thank you, Your Honor. Mr. Kilowald, you can handle it. Thank you.
Jeffrey, I appreciate that.
Oh man. Oh, that's funny.
Yeah, the September 13th. Witnesses were sequestered. So
I know.
when Mr. Marshall was testifying, Ms. Blaisdell was sequestered outside the courtroom. She had no access to any electronics, so there isn't any way feasible for her to have watched or seen Mr. Marshall's testimony. So the witnesses were sequestered, and the officer in charge was present in the courtroom.
Your Honor, just very brief on that. We had a few breaks during, I think what my client is getting to, we had a few breaks during that time.
See, I can't even hear it. I can't even hear it. This is
Oh, he's still here.
Nazi. This is Russia. I can't even hear what the prosecutor or my attorney are saying.
You say this is Nazi? Do we have Godwin's law on the bingo card?
Marshall Brown was allowed to leave his stand, and I believe my client believes when he went out, he may have discussed that with the other witness. I think that's what my client is referencing. Just for the record.
This is corruption. I can't even understand what they're saying.
Voice crack?
Can you hear it? Can you understand it? Don't
So
worry.
the witnesses were sequestered at the September.
I know. The witnesses were sequestered at the last hearing. The witness was not in the presence of the other witness while they were testifying and did not have access to electronic devices in which to hear the testimony. And I heard that very clearly, and I recall that happening. The revisionist history that's trying to be placed on the record wasn't what occurred.
And in terms of going forward in 22 FB 1278, I do have Deputy Mace with.
Does he keep going, or is this it?
Does not have transportation. So the sheriff's department was picking her
Oh, sorry.
up for the, she does have COVID.
Positive COVID test.
Ms. Reiser, but
Oh, he's still going.
not stand, testify. I know Ms. Reiser, but she's just repeating what the officer could be saying under oath for the record, Your Honor.
In this wonderful world we're in, dealing with COVID every day, an officer's going to come report to the prosecutor that the alleged victim in a case has COVID and sees paperwork that's reported to you and somehow or another that's going to be questioned.
Yes, Your Honor.
You got to be kidding.
No, Your Honor.
Let's do this. No, Mr. Kilowog,
Ha!
it's your bed. You're gonna lie in it.
Talk to the
Officer, please
hand,
take your
sir.
stand. If you come forward to be sworn.
I love it.
For the testimony on COVID,
Fine.
The two officers are present in the courtroom
are on the other case. This is about the,
CSC.
right. Let's have him
Cease.
sworn.
Raise your hand. You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, and help you God. Lower your hand, have a seat. State for your first and last name for the record.
Yep, Deputy Sean, SDAN, that's what makes it easy.
Sure.
Can you tell the court where you're employed, sir?
Washington County Sheriff's Office.
And in what capacity?
Deputy Sheriff.
And were you working today, October 4th, 2022?
Was,
And what was your assignment?
patrolling the Lane Township.
And were you sent to Osmond's Way to pick up a victim on a case that you were in?
Yeah, correct. I was working in former that she had court today, one reminder that she had court today.
I have no idea what they're saying, but I was told by Danny that there is another bit of outburst in
And
this
more than anything, did she advise you?
by the defendant.
Even though she advised me that she couldn't do the court date because she had COVID, she showed me hospital discharge paperwork dated October 2nd, 2022.
2022.
Sure.
And you saw that paperwork?
Yeah.
Okay, and how did she?
Amazing. Just a follow-up question. Is there a reason why you went to pick her up? Yeah, it was a written message. Do you know if she owns a vehicle? I'm aware. Okay. And how is it that you interacted with her? I mean, is she COVID right now? I mean, does she have COVID right now? And if so, I'm wondering how you approached her or discussed with her. Yeah, on the front door. She came in the door, and I spoke with her at a distance. Okay. And she showed you some paperwork? Correct. And what was the paperwork that she showed you? It was hospital discharge. And it was from what hospital? Trinity Health. I'm sorry? Trinity Health, St. Joe's. Trinity Health. And did it show a doctor's name on there? I don't know. You don't know? Did you take a picture of that with your cell phone? Did not. Did Blaisdell appear in any way intoxicated or under the influence of drugs? No, she didn't. And how long have you been an officer? 1 year. Thank you very much. I have no further questions.
All right, so that the record is clear, sir, you went to the door. She said she had COVID. You saw paperwork that indicated that she had COVID from a diagnosis or at least a discharge from St. Joe's Hospital of October 2nd. Correct. And as she appeared to you, she was coughing.
Again, if you don't know, the reason why the judge is able to ask questions is that in situations like this, the judge can be the trier of both law and fact and is able to ask his own questions.
Nasally sneezing. Did you have any reason whatsoever to doubt that what she was telling you was true?
No.
All right, thank you. You may step down.
We would request a continuance in 22 FB 1278. The court's next available date. I don't know what the quarantine is now. For the CDC making at least 5 days at the same.
Well, yes, kind of, but I don't know that we're going to be able to get you in 5 days.
Right, I
So,
understand.
so I don't
think we're gonna-
I don't think that's our issue. Our issue is
Sorry, November.
So first date.
I can do November 1st in the afternoon.
It's gonna go from General Finance Court.
The people, the first.
Yes, Your Honor, at 1 p.m.
28 preliminary examination is adjourned to November 1st, 2022, 1 p.m.
Anything? Hmm.
Deputy Bob, OIC.
I guess determined not to participate. How would you like to proceed, sir?
Your Honor, I've made my objection of him not being in the courtroom. I don't know what else to do, Your Honor. I guess I could object to this hearing further, that he's not participating. I'm supposed to advocate on his behalf. I would say, I understand that he said if I can't be in the courtroom. He's still on patient for it, Your Honor. I'm an attorney. I can't. Listen to the problem, asked the court during this matter.
Can't hear shit, Captain.
They have sat down here all afternoon. Would the officers be available on that November 1st date? In the afternoon.
Patrol has been sitting in court for 3 hours. So my preference would be to finish it, do it today. I mean, we'll be kind of running into the same situation again on November 1st.
I don't know if we'll be running in, we know if we'll be running into the same circumstance, trying to balance things and what I will do, however, so that my order can be clear. And if Mr. Bloom at that time elects to do what he has done today and not to participate or participate from afar, that's going to be his choice. I've given, as I said at the end of the last proceeding, I would certainly reconsider allowing him back in the courtroom. However, that is off the table at this point, because he has shown by his behavior today that he cannot conduct himself appropriately. So his choice will be that he can participate via Zoom, or he can elect not to participate at all, and we will continue with the proceeding with him in absentia. He has plenty of time to attempt to try to gather an understanding as to how this court is going to operate. And so if he has time to figure out what his decision is. If there is a request, Mr. Killewald, well, so I'm making it clear that's where this court is going. If there is a decision that he wishes to do that, that will need to come by written motion to me as to all of these supposed promises that he's making as to how he will conduct himself. But that doesn't mean I grant it, and right now I am predisposed not to.
You're saying he wants to be in the courtroom. I have to file a motion.
Absolutely, because my ruling now is that he will not be in this courtroom.
And as my understanding, he gave him,
I get held him in contempt, summary contempt, 93 days.
is that something I can argue in the motion?
If you'd like to, you may, but you can argue whatever you'd like.
It's like, you could challenge it. You're probably not going to win though.
So, and to the deputies, this court doesn't like to waste time, but I apologize to you for the delay and not being able to go forth today. But I think you also can appreciate I'm trying to balance certain things here.
Judge, could I just ask one other question? Is there, and again, I probably, let's say ask this, but is there another possible date in that later in the week, in case my trial goes, that we could have an alternate date that's set, that if my trial goes, it should be done by Wednesday?
Later in the week?
Yes.
Okay, so later in the week, that's not going to happen. My Wednesday is full of townships things. My Thursday is full of every PCC, which you know, and my Friday would be full of a housing docket. So that's not going to happen. It's going to have to be a Monday or Tuesday. That's the only way it will happen.
Could we set an alternate date for the, and again, I apologize to everybody, but could we set an alternate date of November 8th, Your Honor, or Tuesday?
He's trying to judge his patience now.
It's not the date I'm doing now.
Talking to his court clerk here in the off camera.
7th or 8th, Monday, Tuesday.
Okay, folks. Would Monday, November 7th in the morning work? I'm not going to set alternative dates because I'm going to have to use the 1st for something else. So we'll set it for the 7th if that will work for everyone.
I will say, guys, this is normal. This, like, I feel, looking back to when I was a clerk, when I was a law clerk for my judge, it really did feel like so much time was dedicated to fucking scheduling status conferences, scheduling trials, scheduling motion hearings. It was ridiculous.
I think that's fine if you're not gonna try to.
All right, November 7th, 2022, at what time you want me to do it? At 9 a.m. And so, Mr. Killowald, you're requesting that both hearings be set to that time.
Yes, Your Honor, and I do appreciate everybody's consideration, especially the officers. I do apologize. Now that I said, hopefully my trial is off, but if it doesn't, it's November 7th is perfect.
At 9 a.m.?
Yes, at 9 a.m. It'll be in the morning.
Thank you, Your Honor, and I will anticipate giving you a motion within the next several weeks.
They will look forward to reading it. Folks, thank you. And again, to the deputies that took their time, my apologies. All right, is that it for us? Those are my notes. 14A stands adjourned.
Oh, and we're done there. So we're not over yet, guys. Well, hold on. All right. This was sent to me by a viewer. My schedule was difficult. So I haven't seen this. I'm not going to spoil it though. The viewer spoiled it for me as to what exactly happens here. But apparently something exciting happens here that we're going to take a look at. I haven't seen this at all. I hope there's video. I hope there's audio. Uh-oh. There's no audio? Oh, that's disappointing. Hold on. Let me confirm whether or not I downloaded it correctly. I hope there's audio. Oh no! He didn't put the audio. Shit. All right, I'm gonna fast forward here. There's a body worn camera footage being shown. I'll talk to my viewer and see if they can get me the audio. It's like I guess it's like a prison incident. It looks like it's a prison incident. Oh, by the way, guys, while the audio is quiet, I sent Danny a gift that only Skyrim fans can understand, and she like both loves it and hates it at the same time, which is exactly what I was hoping to get. Alpha, nope. But it's definitely a standard Skyrim meme. I hold on, Danny. I want them to try and guess for a little bit and see if they understand what it is. Nope, not a sweet roll. Remember, she both loves and hates that she got it. That's a clue. Nope. Not a Talos is not a real god. Not a copy of the Lusty Argonian Maid. Not an heir to the knee. Nope. Not that, Kuma. That's a good idea. Nope, not that, Alpha. Oh, I did get her a skooma candle, but that's a separate gift. That's not what I got her that she just got today. Nope, not full Daedric armor. All right, I don't think you guys are going to get it. All right. I sent to her a replica of Meridia's beacon, and it should have included a note that said a new hand touches the beacon. And it's and she sent me a message saying that she sent me a message that like with a picture of the package, and she's like, I can feel it and I know what it is and I don't want to fucking open it. And I kept on begging her to open it. Do it. You have to now. Oh shit. Oh, he fights. Oh, this guy fights. Oh. 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 And yeah, he gets tased. In a bathroom. That's humiliating. I like how everybody suddenly becomes calm after that. Well, unfortunately, the person that sent me this did not get the audio, so unfortunately that didn't work out. But John, I think I found the video you're talking about with Unclean Hands about this incel dude who pepper sprayed women getting caught. I want to know if this is the same guy, and you'll have to confirm it for me.
I've got good news and bad news, and I've always found it's better to get the bad news first. Just go raw and no rubber and hit you with the cold water right away. Force feed you the vegetables so that way the dessert tastes even better. The bad news, I'm about to show you an insufferable asshole, perhaps one of the most miserable people to listen to on the planet. The good news, he's about to be arrested. Let me introduce you to Johnny. Johnny is the epitome of turbo virgin. I know this word gets tossed around a lot, but he is a self-proclaimed incel and one of YouTube's most prolific stalkers / woman harassers. This goofy goober looks like if Raymundo from Rocket Power and Tommy Wiseau did a fusion dance and
So basically, he finally got arrested recently. Good.
Created the world's most socially inept asshole. Now, Johnny's whole shtick was he would wait outside of bars, clubs, and even parking garages, literally just fucking live in parking garages, until he saw the slightest hint of a human female nearby. And then he would get his phone out and start recording himself, following them, insulting them, and demanding they fuck him. And he'd follow them for what felt like miles. These videos would go on for so long, and always it would end up the same, them threatening to get the authorities involved because they were literally scared for their lives around this guy because he was completely unhinged. And he continued this shit for about a year. I've known about his pitiful existence for quite some time, but just never really wanted to bring any attention to it for obvious reasons. But now he pushed the envelope a
Oh, so assault by Costa Mesa police. So then Unclean Hands. Okay, we'll watch Unclean Hands video because apparently he finally got caught.
Bit too far and flew a bit too close to the sun, and his tiny little micro dick burned up. He actually assaulted a woman who defended herself from him. He pepper sprayed her, and it was after he instigated the entire conflict. And now that video has surfaced and the authorities have gotten involved, and they're looking to arrest him and potentially charge him with assault with a deadly weapon, as well as a hate crime and the discharge of tear gas. The article also alleges that he was
I mean, yeah, women are a protected class, so I guess under California law, that could qualify.
Recently arrested after getting kicked out of a club with his friend, and while getting escorted out, basically claimed white power and some other shit like that.
Oh,
which sounds
also
par for the course for a fucking homunculus like this guy. Imagine evolving for millions upon millions of years and ending up like Johnny. What a bad fucking deal. Just an actual shit stain on the planet. But anyway, I'd like to show you the video that is going to lead to his arrest. What triggered it all here and started this chain reaction where finally it looks like he will no longer be terrorizing innocent people on the streets.
Can I hang out with you?
That guy just stole my car, so he's...
Where'd he go?
Oh my god.
Newport Coast? Huh? Can I hook up with you? What kind of vagina do you have? Is it an innie or an outie? Does it have beef curtains?
I'm gonna call the cops if you don't.
Yeah, fuck you.
Yeah.
You're annoying, dude.
Why are you calling me?
Because I want to fuck.
That's his real voice, by the way. He's not putting on some kind of show. He's not playing a character. He genuinely sounds like one of the Looney Tunes character Inhaled Helium forever. It actually just sounds like he's making fun of a stereotypical incel demanding tindies from mommy. That is just his normal state of being. He does it unironically. Man's collected all the infinity stones of cringe and ascended to a level beyond pathetic. I'll go ahead and play the rest of the clip.
My fat ass cock is ready to get hard for you.
The cops are coming right
Why
now.
would you call the cops on me, bro? I'm just speaking.
It doesn't matter.
Fuck you, you little bitch, you little void. Oh, you little Whoa, what's wrong with you? Chill out, chill out, chill out. Hey, chill out. Chill out. Chill out. You just kicked me in the balls. You back up.
Well, good.
You back up.
Probably the only action those balls have ever had.
You back up. Throw that at me, you're gonna...
Oh! Nope.
It's an absolute shame that he didn't lose his footing and fall down the stairs in front of him.
Yeah, that's not self-defense. Nah. That's not self-defense.
I've never prayed so hard for shoelaces to malfunction in my life. So yeah, the guy's obviously a coward. He carries pepper spray because he'll push people to the absolute edge, and when they finally do, like, defend themselves, he'll just pepper spray them. Now, of course, there's almost 0 people in the world that like this guy and can stand to be around him. I imagine even his own parents drink themselves into a dreamless slumber every single night, just regretting the day that they conceived this failure. But I did see on Twitter a couple of people blame the woman here, saying she assaulted him first. Now, of course, Twitter is just this disgusting cum dumpster of the most brain-rotted clowns imaginable, but I did want to at least talk about it. There's such a drastic difference between throwing a shoe after being verbally harassed for however many minutes before filming, because he was doing this even before he started filming. This is only a piece of the video. To be harassed that long and then just respond by throwing a shoe is completely different than getting fucking pepper sprayed. It just can't even be compared. That's like if a kid shot a spitball at you and you responded by hitting them with a sledgehammer. Pepper spray is hardcore. It's a legitimately painful experience. From everyone I've ever known to be pepper sprayed, they have said it's the most painful thing they've ever experienced. Luckily, I haven't been pepper sprayed, but I know from what I've seen and the people that I know that it is something that isn't just laughed off or something trivial. So it's just...
Yes, pepper spray does not tickle. Let's put it that way.
Not even in the same ballpark. And she did it in what I consider to be self-defense. This was like 3 a.m. The witching hour. Don't summon Freddy Fazbear at 3 a.m. kind of shit. Like, this is haunted. This guy is hanging out at a parking garage in the middle of the night, being fucking creepy and weird, saying things like my hard cock is ready for you and shit like that. You don't know what he's gonna do. That is a dangerous person. So to like get him away from you and throw a shoe, I think is like an appropriate response. And especially because he already proved you can't just walk away from the confrontation, because he had just previously followed a woman all the way to her car who was panicking, making up a story about having her car stolen and visibly uncomfortable and worried for her own fucking life. So her trying to scare him away like a pigeon on the beach was really like the only thing she could do to like diffuse the situation and make him stop. And then he responded by ruining his life with the pepper spray, because now he'll be arrested for it, and I cannot fucking wait. I think that is extremely exciting news that this guy is finally.
I imagine Charlie's gonna talk about it too,
because it's been going on for quite some time. He has a long history of doing this shit without remorse, and this is beyond deserved. I'd like to show you just one more clip that survived when his channel got nuked. This is just another example of the kind of shit that he would do on a regular basis.
Hey, are you single?
Oh God, why?
Are you single?
Yeah, I am.
Oh, you think I'm hot?
Ew!
Oh,
What the fuck is that hair?
I can't even see without my glasses.
Oh, really? Do you live here?
I don't even know.
Do you want to hang out?
No.
What are you gonna do later?
No.
Sleep? Can I come sleep with you?
He's got a man. Oh God, why?
No, I'm good.
Luckily, she eventually escapes from the seventh circle of hell there, but this was his content. This is all he would do. He would just wait to find women pretty much anywhere, really, and make them as scared and uncomfortable as possible and film it. That was his entire existence. That was his whole purpose. And now it's finally over. Can finally breathe a nice sigh of relief. You won't accidentally see this man sitting on a fucking park bench somewhere and ruining your day. So I just...
Alright, here it is.
Hey guys, I did a video quite a while ago about Johnny Young. He's an incel, self-proclaimed incel, that was pepper spraying women and stalking women through malls and after dark at clubs on the outside. And they were trying to arrest him and he ran away. Well, they caught him somewhere in Mesa, Arizona, I think. Anyway, here's the news footage.
A man wanted for violent attacks on unsuspecting women has been captured and transported back to Orange County.
Holy shit!
Johnny Devin Young is a self-proclaimed incel. He posted videos of himself pepper spraying and harassing women on his YouTube channel. The 25-year-old from Anaheim was arrested on a warrant in San Mateo County. Among other things, he has been charged with 4 felony counts of assault with great bodily injury, illegal use of tear gas, enhancements for the personal use of a deadly weapon, and 8 felony hate crime enhancements. He faces a maximum sentence of 13 years in state prison if convicted on all counts.
It looks like he was arrested in Anaheim. I believe Anaheim is in California. So he was still in the same state as far as I know.
Well, unclean. No, I thought they said that he was arrested in Mesa, Arizona, and then transported back to California.
But yeah, you'd remember the guy if you saw the videos where he was running around pepper spraying women just randomly, just because they didn't want to date him. But he's a self-proclaimed incel, so, you know, it's guys who can't get a date. What a life. Anyway, hope you enjoyed. Bye.
Ugh. Jesus. Well, I'm gonna leave. I wish I didn't leave it there, but hey, we leave it on a high note that he got fucking arrested, and but the problem is it's California, so fucking he'll probably be out in like 9 months because it's fucking California. So I was gonna say, hey, he won't be out for a long time, but no, this is California. So he'll be out in like fucking 9 months or something like that. All right, I think I'm going to stop it here before it gets too crazy. So, I want to thank you guys for watching. I haven't been following much on News Now Patrick or Sheepdog. I know they're apparently suing each other. I mean, all the best. I don't give a fuck about either of them. So, what do I care? If they want to sue each other, go for it. I mean, what's it matter to me? Yeah, they're like suing each other, apparently, Hitchbot. Or something like that. What was the other thing I saw earlier today that was pretty wild? Oh, it was Code Blue Cam. Oh, these fucker. Oh, it's these fuckers.
On June 15th, 2022, a Racine County Sheriff's deputy was monitoring traffic when they observed a vehicle traveling at a high rate of speed in Racine, Wisconsin. The deputy's laser unit displayed a speed of 43 miles per hour in a posted 30-mile-per-hour zone.
We're going to be at the mobile gas station off of Spring and Osborne.
The driver was identified as 31-year-old Kelly Zeminski and the passenger as 37-year-old Joshua Zeminski. Upon approaching the vehicle, the deputy noticed 4 children in the back seat when the vehicle only had 3 seatbelts in the back.
What does that plate come back to? Hi!
Why is he pulling us over?
Can you roll down this back window? Hi guys. So I'm Deputy Bill from Racine County Sheriff's Office. I pulled you over for your speed. You know how fast you're going? What? So 44 and a 30. Copy, thank you. definitely gonna take that to court and dispute it because that's not what my doctor said.
Okay.
That's fine. I mean, it's fine. You can give me the ticket. Oh, that's just my insurance stuff. Yeah, I need your driver's license. Who's the registered owner? I am. You're the registered owner? Yeah, I'm still waiting on my plates to come in the mail, but my registration, where's my, oh, I gave him my title. The what? I gave my title to his mom.
What's our car?
The registration.
I gave it to her. It's in the goddamn hand.
Okay, sounds good. So you're Kelly? Yep. Okay. Do you have your driver's license?
I gave it to her.
She's looking for your ID.
Oh, no, I don't have an ID on me.
Okay.
She has a license. I don't need to give you my name.
You just said it's your car.
It's her car. I never said it was my car. It's her car. I'm her husband.
I don't know why you're being so argumentative with me. Because I have to go to work.
Right.
I don't have time for that. You're going to work with all the kids?
We're going home.
I'm taking them home and then I'm going to work. I work at 8 p.m. I have to shower and stuff. I took my kids to the beach because that's what we do on holidays. Okay. All right. How old are the kids?
What is that, man?
Don't know. You don't know the age of your own
We have a lot of kids. Is this?
Okay, so I imagine the officer could probably see that there are 4 kids in the back seat, but only 3 seatbelts. So one of the kids is without a seatbelt.
Shit necessary, right? It's
I did see that, John.
Arrest you're on at the Riverview Manor, 580 Madison. When did you buy the car?
A life alert alarm.
What?
Contact was made.
A month ago?
Would you like me to call the guy that sold it to us?
No. I didn't ask you to do that. Do you have that stuff? Do you have any weapons in the car you know about?
No.
No? Okay. Any drugs in the car?
No.
No? No marijuana?
No.
No cocaine? No heroin?
I said no to drugs, that's a no.
Okay.
There's no alcohol, no guns, no what, no knives, no drugs, no weed. I got some prescription pills.
Don't reach for anything. Okay? You guys are just being argumentative and that's a little
You're
weird.
asking a bunch of fucking questions that ain't shit. You pulled her over for speeding, you got her name, you've seen her insurance, you've seen her registration, and you're still questioning how old are my kids, this and that.
Well, I only ask because they have to be in car seats, and there's 4 of them in a 3-person seat.
Okay, I got a car seat in the trunk. Can you
Okay.
put a car seat in this kind of car and fit all these kids in here?
But there's 4 kids, 3 seatbelts. 4 kids, 3 seatbelts. Never mind the car seat. Ignore the car seat. There's 4 kids, 3 seatbelts.
Well, you don't have the space to fit.
Obviously
in the
not.
back seat.
That's why the car seat.
So
ain't
it's
in here.
illegal.
Then why do I take it for that too?
Okay. So do these kids?
No, it's just gonna-
You just have the one seat then, or?
I got booster seats at home.
Okay.
And I got a car seat.
Are those your kids?
They're
or?
all my kids.
Okay. Do you have your ID on you?
I don't need to give you my ID.
Yes, you do.
No,
Well, now that you said that they're your kids, you're a parent, and so you're going to get a ticket too. That's why she needs your information this time. That's why she has probable cause to ask to get your information. Is because now that you said that they're your kids, you're also responsible, and you can get a ticket as well, along with her.
I don't. By law.
5'9". Can I have a cover? They're being argumentative.
You're gonna get arrested. Just give her your fucking
I don't have an ID on me. I said it 5 fucking times. My name is Joshua Zeminski. I tried to give her my prescription pills, had my name on it. But by law, she told me, by law, you have a driver's license.
40 is fine.
I wasn't driving. You have a license.
How do you spell your first name, sir?
Joshua.
Joshua.
Yep.
Joshua, your middle initial?
Joseph, J.
J. Your last name?
Zeminski, Z-I-M-I-N-S-K.
Zeminski?
Yes, ma'am.
What's your date of birth?
Would you like to see my prescription pills from the doctor?
Yes, they're fine.
Oh, no, I took them out.
You gave me your name. I don't need to see your prescription.
I'm frustrated. I got a lot of shit going on. Fucking, I don't got time to do it.
Okay. All right. Well, why don't you guys just stay in the car for me? All right. I'll be right back. Thank you. They're being extremely argumentative. She said I didn't pull her over for speed.
Would you stop her
for speed?
Okay.
So
For speeding.
43 and a 30. So she was argumentative right off the start. And then there's 4 kids in the back seat and no car seats. There's a 3-person seat back there. So.
What's their problem?
They're only gonna write me tickets for the 2 kids that are young enough to be car seats, right? The other 2 are. Okay, well you still, like I said, you still have 2 of them. Saying, don't write me tickets for all 4, that's only 2. Gotcha.
Jeez, so the cop's like, okay, I'm gonna write you 1 ticket for child endangerment, because there's only 3 seatbelts for 4 kids in the back seat.
Too bad we don't have a canine. Too bad we don't have a canine.
Kelly and Joshua have an extensive criminal record, but they are mainly known for their involvement in the Kenosha protests and riots in August 2020.
Oh! So they were involved in that mess back in 2020, the Kenosha riots, which I imagine most of my chat understands what that involved.
Both were seen starting fires and blocking law enforcement vehicles during the riots, as well as Joshua firing a gunshot in the air.
Were the side windows pretty dark too?
Oh yeah, they're like the same color. You can't see inside at all. And then when I first stopped him, I didn't even approach the car. He's hanging out the window. Why'd you stop us? Yada, yada, yada.
Negative. It was a Macon case. We got the information from Walmart.
She can't drive with all 4 kids in the car like that, so I guess she can't go anywhere either.
Well.
No, we're on a traffic stop. Oh. What? What for what? How long does it take to make some tickets? To what? How long?
Are those temp tags?
How long does it take just to make some tickets?
Those look like temp tags too.
As long as it needs to. I said, how long does it take to write some tickets? I said, as long as it needs to.
Can you go test their tint? Thank you.
Which window?
Wait, SGV is trying to skirt the YouTube rules. Can't do that.
Front and the back.
Can you roll up your front window a little bit?
Can I roll up my window?
Yeah, can you roll it up just a little bit?
Oh, the fucking tint meter.
The tint.
All right, that's good.
Well.
Full. $51 front, $4 back.
Kelly was cited for excessive tinting, operating under suspension of registration, and violation of child safety restraint. Second offense.
Wait,
Joshua
second offense. So she was already hooked up for that before.
was also cited for violation of child safety restraint. Second
offense.
Okay. So, a couple things here. You got your citation for the violation of child safety restraint, which, looking through your history, this is the second offense for you. So you got one for that. You, sir, got the other one for the second child, so you got a citation as well. Okay. And then your registration is suspended due to 2 unpaid parking tickets in the city of Racine. So you got a citation for that.
How is my registration suspended when I just registered the car like a week ago?
I don't know. You'll have to work that out with Racine. It just says it's suspended due to
You
unpaid parking tickets.
Tell him to pay his motherfucking shit, because I ain't
Okay,
doing it.
and then you got another one for excessive rear window tinting, because this is at 4%.
My law is 35% in Wisconsin, and I seen you need it at 51.
The front one.
The back said 50. 4. Back seat again?
Sure, that's fine. So you don't have to go to court for these if you don't want to.
Well,
But
I
if
don't
you
care
like
about your
to,
consent, John.
Court time's going to be July 21st at 2 p.m. in the afternoon, okay? So I'll give you these. I put your ID in there, and then this is his.
Here, babe.
Yep.
All right. Do you have any questions?
Nope.
Okay. You can't drive because they don't have proper restraints.
I have my sister on her way with another. I'm going to get my car seat out of the trunk after y'all leave because I don't trust not to get tased. And my sister's on the way with a blue.
I don't trust not to get tased.
Take care.
They were both considered guilty due to a no contest plea and owe $700 in citations.
Oh.
Good. Thank you.
About 2 months later, they were both charged with numerous felonies for allegedly attempting to rob a Kenosha man at knife point. Both are currently being held on a $100,000 cash bond.
What the fuck?
Want to represent Code Blue Cam? Check out our newly released merch in the description below. As always,
Oh my
thank
God.
you for your support.
Parents of the fucking year, exactly. Tried to knife somebody at knife point, and at the time of the video, they were being held on $100,000 bond.
On June 12, 2022, police were monitoring city surveillance cameras when they observed a female sunbathing at a park in Wausau, Wisconsin. The female, 24-year-old Talise Machapoto, had an active felony warrant for failure to appear.
All right, FTP appear. FTP warrant, I should say.
Officers arrived at her location and noticed she had left the park and was walking across a bridge. They yelled at Talise several times to stop, but she ignored them and continued to walk away. Another officer in a squad car pulled beside Talise and immediately detained her.
10-4.
I don't give a f.
Why you gotta walk away from us? You know we're gonna drive.
Dude, I was walking home for a second to go check out an old man.
Me asking you to stop though? Really
No.
commanding you to stop? Here's me talking.
Don't f- command me. I'm not a f- dog.
We have a warrant, so we have to talk to you. We have to take you to jail.
And I'm not a f- dog.
She refused to cooperate with the officers and demanded a female officer to conduct a search.
Yep. Needle.
Where? Okay. Where's that? Just so I can take it out.
I don't have a f- needle. Seriously.
Any knives or anything like that?
Nope. I wish.
Oh, okay. Can you widen out your stance a little bit for me?
Nope.
Please?
Nope. I request a f- female.
We don't have a female officer.
That's f- bullshit. Then you better take me to f- jail right away.
Well, we're going to take you to jail.
Well, then I request a f- female.
Okay. And they'll have one at the
I
jail.
want a f- female.
Right? What are you yelling at us?
They were advised the nearest female officer was in another town, approximately 35 minutes away.
So I don't know what the general policy across many police departments is that you would have a female officer pat down a female suspect. I would also imagine that there are probably exceptions to that if they don't have a female officer on duty, if they don't have a female officer, or if they don't have a female officer, within a reasonable time that can get there, that can do a pat down. I'm sure there are exceptions to that. That notwithstanding standard department policy.
It's always kind of a creepy feeling.
Don't f- touch me. Stop touching me.
What you have to understand is
I don't care. I'm requesting a f- female.
We're working on that, please. Nope. Right, there's not a female.
Take me to f- jail. Stop f- touching me.
And I expect that is also part of their policy not to let a suspect into the back of their car without doing a pat down, even if they're handcuffed. So I imagine that they can't do that either.
Stop.
Just lean against the
No. I want a f-
I see what you did there, Robert.
She then began hitting her own head against the hood of the squad car, demanding to be taken to jail.
Get the f- off me.
Can I explain something?
No, I have a right to request a female.
And I
Then
asked.
take me to jail.
Oh my God.
Dude, I'm gonna start swinging up on you guys.
I
Get
asked.
the off my property.
Stop.
No. Take.
I think that officer has like a tattoo of like the fucking Roman Colosseum on his arm. It's fucking awesome.
Take me to jail.
I asked if there was a.
Oh!
Please,
Jail.
please.
Nope.
Jail.
Stop.
No.
You want to switch spots with me? You know.
Where do you want to search those pockets for me?
No. Oh, you douchebag.
Stop.
Ow.
You gotta stop resisting.
No. Ow.
And the last thing we want is.
Stop.
requesting a female! Get the off me! Get the off me!
When an officer attempted to search her, she allegedly turned towards him and spit on him.
I know. That might very well be, but I can't allow you to do that.
Get off me!
Talise.
I'm requesting a female! I have a civil right to request a female! Then take me to jail!
And we're working on that.
Oh, no! And wow, that's pretty obvious right there. She just spat on him.
One
Then
available.
take me to jail!
And we're working on that. Talise,
She spit on you?
yes.
Okay.
Well, that's another charge.
Take me to jail!
Talise, I was just about to ask.
Take me to jail! No! Take me to jail! Good, because I'm requesting a female officer!
I know you are.
Oh, you mother dead.
You good on
You pigs! Touch me!
If you don't stop resisting, I'm gonna
Ow!
Stop!
Stop!
spray you if you don't stop resisting.
No! Ow! Stop!
Oh my God!
Stop.
Jesus Christ!
In jail!
I can't.
Ow! Stop!
I can't.
Stop!
All right, let's get her in. Get your door open.
Got her? Yes,
Yeah.
I got her. Can we step back from the squad? Thank you.
No!
Yep. Okay, we're gonna go.
You
Here.
can't wait till terroristic threats. Ass cops.
Did she actually spit on you or just
Spit at me and hit here, and then some of it hit my arm.
3151. Local warrant. The Marathon County warrant.
Policies and law. I know, right, John?
We can't confirm this was on her, right?
I didn't know.
I'll just dispose of it.
Yeah, most of it hit my car, but.
You go for a drive? Okay, I'll follow you. You want me to follow instead since you're out of here soon? Yeah, I made myself primary. You guys took the other 2 warrants.
Yep.
So, yeah.
Oh, yours then.
Okay. I can walk quick. I'm not worried about it. All right. What's that? It's going okay. Enjoy the weather.
Look at these tyrants. Look at these tyrants hook up an innocent female doing nothing but having an outstanding warrant. Fucking tyrants.
They medicated our guy here.
I don't know why you guys get shot at.
No, what?
Y'all are fucking pieces of shit.
57202, can you call HCC? Did she throw her head back and hit you?
Huh?
She threw her head back and hit you?
She attempted to.
I couldn't tell if she made a contact. It looked like at one point she did, but I'm not sure.
Well, and the whole time she was trying to use her legs to like mule kick back at us.
Yeah, I had that one pinned up against the
so she never
tire.
got me.
When I went to go put her in a compliance hold, but then I think she started to kick out again. So. Is that cool enough back there for you?
Yourself.
Okay.
Fuck on my face.
Okay.
Talise was charged with felony counts of battery threat to an officer, bail jumping ×2, and discharging bodily fluids at an officer, misdemeanor counts of resisting, bail jumping, and disorderly conduct. All the charges were dismissed.
Really?
However, she was found guilty in her other cases and received a sentence of several months in jail.
Lame.
Want to represent Code BlueCam? Check out our newly released merch in the description below. As always, thank
Honestly, that's disappointing. How all of those even if she got hooked up for the original reason why she failed to appear, that all of them were dismissed is fucking. Ugh. They probably did cut her a break, but that's all right. I'm gonna stop it here before I go too crazy. I got work in the morning anyway. All right. Take care, guys. Have a good night. Go check out who else is live right now. I think Natalie's live. Mike is live. Skeptic is still live. So, hey, go for it. Oh God, he's fucking live.
With probably because we got some super secret drops for you folks, and the
Josh is still alive apparently. But I'm not dealing with that bullshit. I have far too far better things to do. The drama is getting
2 weeks ago.
All right, the last thing I need right now is more streamer YouTuber drama dropping. I mean, I've been following it myself, but goddamn, I don't need that, and I'm sure none of you guys need that either. Y'all don't even know about this Twitch YouTuber drama, so forget it. All right, guys, take care. Have a good night, and I'll see y'all tomorrow or Friday. Yeah. Adios. Take care.